Apparently not ready for me though, because it says host disabled video.
Okay, we have Wayne County Detention Center. Are you on there? They don't come on to it. Okay.
And it's just gonna go to cut it.
Commonwealth versus Colton Addison.
Judge, he's here, I don't think he, I don't think he like to.
Open the door and tell them the courtroom's open. Just tell everybody the court's open.
And we've already got Monroe said that.
Commonwealth versus Colton Abson, 24 CR 0001. Are you Colton Abson?
Yes, Your Honor.
You born in 1998?
Yes,
Last four digits of your social security number 4431.
yes.
We're here today for pretrial conference. What does the Commonwealth have to say?
Your Honor, I spoke with Mr. Pennington Furnace with the prover's name, Sergeant Richard, and I had a lengthy conversation with him. He informs me that Mr. Addison is ready to go and he can be in basic training in 5 weeks. So I'm moving to dismiss the case with prejudice. For some reason, if he tries to back out or something, I'll have to try to take the thing aside, come back on the case. I don't think he will, but I want him to go.
Well, good luck to you, Mr. Abson. It's an opportunity for you to turn your life around. I hope you take full advantage of it.
Thank you, Judge. Good luck, Colin.
Christy Beatty.
That's
Christy Beatty. Commonwealth versus Christy Beatty, 24 CR 0019. Are you Christy Beatty? You get behind the podium. Were you born in 1974,
76.
76? Last four digits, your social security number 2047.
Yes.
You're here for pretrial conference. What's the Commonwealth have to say?
Your Honor, we probably need one more negotiation day because, we just furnished the lab this week in this case. I was thinking you can't do it if you need support.
What's your negotiation date?
We're gonna do, Cumberland in Clinton County here, not in Clinton County on the ninth, at 9 o'clock, June the 7th,
June the 7th?
at 9 a.m. The roll counties here.
You're gonna be here, the next time you're to be here is June the 7th for negotiation and June the 13th for your next court date. Both of those are conditions of your bond, okay?
Okay.
We're on the abstract with all.
Eric Claywell. Eric Claywell.
Mike, on my name?
Yeah, Eric Claywell.
Yeah.
Look, come on up here. Commonwealth versus Eric Claywell, 19 CR 0060. Sir, are you Eric Claywell?
Yes,
Were you born in 1974?
yes.
Last four digits, social security number 9699. You're here today for a pretrial conference. What, Mr. Stockton, Mr. Cross, when you come around on this side over here, your client, Mr. Stockton. Okay.
Yes, Your Honor, this is a case that's lingered for some time and for whatever reason, it never got back on the docket and I didn't realize it was pending. So if we can have a negotiation date, June the 7th at 9 a.m.
Yeah, on June the 7th at 9 a.m., you and Mr. Hoover, your attorney, will appear to negotiate on the case. And if there's a resolution, you come back on the 13th. And really there's set a trial date to dismiss it or guilty, whatever the resolution is. So June the 9th at 9, June the 7th at 9 a.m. and June the 13th, and both of them are conditioned to your bond, sir. Thank you very much. Elijah Coria. Alicia Coria. And is there an active warrant out in this case?
It was served this morning, Your Honor.
She needs to be processed.
She already has been.
I just finished that, sir.
Been good. Ms. Coria, were you born in 1984?
Yes, sir.
Last four digits, social security number 2380.
Yes, sir.
Okay, you're here on 24 CR 0025 and 24 CR 0026 for arraignment. You know, right to remain silent, you're represented by counsel. In 25, the grand jury of Clinton County has returned an indictment charging you with assault, third degree, operating a motor vehicle under influence, disorderly conduct, second degree, resisting arrest, and escaping second degree. In 24 CR 0026, the grand jury's charged you with operating a motor vehicle under the influence, aiding or evading in first degree, and reckless drive. You understand those charges?
We do, Your Honor.
Did you understand the charges?
Yes, sir.
Okay, you acknowledge the identity of your client, receiving indictment, away formal reading, arraignment, interpleading not guilty, reserving all pretrial motions.
We do, Your Honor.
Okay, I'm signing a reciprocal discovery order among them that will require the Commonwealth to provide you with certain information to prepare for defense. You'll be here on June the 7th for negotiation.
Your Honor, I'm gonna be out of town the 13th. Could we move these to the July dates?
No,
Okay.
we should come to Cumberland County.
Okay.
Okay, but are you gonna be here on June the 7th?
No, Your Honor.
Okay. When are we in Cumberland County? How long are you gonna be out of town?
Just for those 2 weeks. First 2 weeks of June.
Let's see what I can get some.
So 27th.
Okay.
Okay, well, you check. May 23rd.
Okay. All right. Cumberland County, May 23rd.
And Mr. Stockton, what did you say the negotiation day was gonna be?
Well, but I'm gonna have all three on June seventh, but Cole County will be, the Cole County, Cumberland, and Clinton will be here on June seventh.
What are we gonna be on May 23rd?
May 23rd to come.
Judge, if I may, May 20th is negotiation for Cumberland, that
Yes.
Monday.
So you're available on May 20th?
I've got depositions in a federal case on the 20th, but I can get with Mr. Stockton before the 23rd.
I'll schedule it for May 20th and 23rd and work with you, okay?
Okay. Okay, that'll work.
Stephanie D. Celestio.
No, that's all I have, to be excused.
Yeah.
Thanks, sir.
Thank you.
Yes, Your Honor.
Stephanie, turn your, oh, I was gonna say turn your camera on.
I got it.
Okay, are you Stephanie D. Celestio?
Yes,
Okay, this is 24 CI 0012. Were you born in 1979?
yes, sir.
Last four digits of your social security number 3011.
Yes,
Mr. Stockton, what do you have here?
Your Honor, my understanding
Come up with
is,
the microphone.
my understanding is that she has a hearing as regards disability benefits in June. My understanding is Mr. Pena and I agreed, subject to the approval of the court, that she has $4,000 posted cash bond, that bond,
What's the charge here?
it's flagrant non-support.
Okay.
And she owes about $4,500. The $4,000 bond will be released, $3,000 would be applied to the arrearage, the $1,000 would be returned to her sister. And she would be released on an ROR bond to appear in person on the July motion day here in Clinton County.
That'd be July the 11th.
Yes.
Okay.
If that's all right.
I'll sign an order to that.
Thank you, Judge.
You understand that, ma'am, what they just said?
I'm to be there on July 11th.
Yeah, you'd be here on July 11th. They're gonna release 3,000 of the bond to help pay your arrearage, 1,000 back to your sister, and you'd be here on July the 11th, okay?
At 9 a.m., I'm sure.
Sister's name, so we can put
I
that
think
in
it's
order.
Sabrina Patrick.
Yes, that's her name.
Thank you very much.
I'll be in touch, Stephanie.
Brian Gross.
Thank you.
Brian Gross. It's active warrant out for Mr. Gross. Mr. Stockton,
Yes.
NCIC, or we? James Craig, it's a Cumberland County case.
Without James Briggs, so.
James Craig,
Judge, he's in a dare.
okay, we're moving back to Dare Detention Center then. Michael Likens. You want, what kind of what was it?
Your Honor, the court, this is the one before issued a summons. And Mr. Lyons was the one that was in Indiana, and went to, turn himself in. It served summons this morning and it's been recalled, but nothing else has been done, so.
Commonwealth versus Michael Likens, 24 CI 0008. Are you Michael Likens?
Yes, I am.
Born in 1960. Last four digits, social security number 3813.
Yes, sir.
Okay, we're here for the purpose of the arraignment. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you receiving stolen property of firearm. You understand that charge? You understand what the charge is?
I just,
I'm not asking where you did it or not. You understand what you're charged with, what you're accused
I
of?
do now, yeah.
Okay.
I just received it.
Sign a reciprocal discovery. Okay, now, Mr. Stockton, where are we on this?
Well, he's just now been arraigned, so I'd ask for the negotiation day on the 7th of June.
Okay, has he been processed?
No problem.
Okay, you need to be back here on June the 7th at 9 a.m. and June the 13th at 9 a.m. What's his bonds? He made,
It's just a summons.
well, I think there was I issued the summons so we wouldn't have to be in jail.
Items we issued with one of the rest. Mr. Ross requested a summons because he was out of state because of his health issue.
Right,
He was supposed to appear last month on the summons, did not appear. He was supposed to have medical records presented by a certain date or a warrant would be issued
That is correct.
and didn't appear today.
And I'm his lawyer, I'm not his doctor, so we couldn't just get what the court wanted. So,
do you have any medical records?
Yes, I do.
Have them with you?
No. I haven't got them with me, but I'm still underneath doctor's care. But, my other daughter's, it's all on, but I can get my phone, it's on my phone, it's on my health issue thing.
we previously, Your Honor, furnished some records to Mr. Stockton's office. I think what the court wanted was.
Mr. Stockton, are you satisfied with the medical evidence that you received?
I've not seen anything, but his appearance today tells me that he's going to come to court, so I appreciate that.
Does he live in Indiana?
Well, I'm staying in Indiana right now for medical issues. I still got doctor appointments and stuff.
Okay, well, just have him sign a waiver of extradition and I'll continue on the same situation.
Sign right there. Did you wait, sign what Melissa has for you and then wait for me outside in the hall? Mike?
This is signing a statement that you'll come back to Kentucky without
Oh,
getting you extradited. Just stay there with him, Mr. Cross, and let him sign that. Okay.
we're not going to back.
What days you gotta come back?
Seventh, June. And then the 13th. And wait for me outside in the hall.
I don't have to think it out.
Brian Markle.
No, it doesn't surprise me.
And Judge, I will say, I did send him a message letting him know this, I think this kind of got off kilter, but I only received notice of this, I think, yesterday or the day before that it was going to be on the docket, so.
The problem is, it was supposed to be on the docket last month. For some reason, my motion for trial date never made it on the docket. And then I said, read notice at this time. And you've been telling me.
And he was here last month.
What's coming out this time? If you want to file a motion to suppress, that's the reason this case has been delayed and you never filed one. So now I'm asking for a trial date, he's not in court. So there we are.
Ready? What do you have to say?
And Judge, I'm fine with setting the trial date. I understand my client's not here, but again, I was only provided notice of today's motion yesterday. I did in due diligence let my client know.
Did you actually talk to him?
No,
Well, he knew to be here today. He wasn't here last time.
I guess,
Yeah, Judge, he
I guess
wasn't-
this case was just gonna disappear.
and Judge, also, he was actually here in court last month, last rule day. He was
What
here.
is in charge here, Mr. Stockton?
Burglary, they often cultivate marijuana. It's not his first rodeo. Mr. Markham knows as much about the court system as I do.
Okay, you got your calendar?
I did, Judge.
Well, I want him to be here to set a trial date, otherwise he'll say he didn't get notice.
I'm gonna set a trial date. He's gonna, if he's not here, we'll know where to find him.
Okay.
It'll take one day to try this. I'll just take one day.
One day.
You have any expert witnesses for me to get a hold
No,
of?
no, local. It's. And somebody's on vacation. You check.
This year. We said. Well, they don't come on to you. So. Some jury. On this, right? Yeah, he's in Washington. Listen, they would even not. It won't have what the reason we can see. Yeah. We got the old jury and we got the new jury. And I informed the new jury that there were moving trials to schedule. That doesn't affect the old jury. But there's concern in my office that there might be confusion if we set it one day.
What about setting it July the 23rd and we go back on the 22nd? For all this day. That's all I told. I don't know if you got it available that day. I'm available the 23rd, 24th.
Well, we got a trial schedule.
Oh, okay.
Clinton and Cumberland County trash.
What about the 29th through 31st of July?
Don't want to set one for that day.
I'm
How about the 19th, Friday the 19th?
July. I've got, I can move it, but, still. That's before the 22nd.
I'm curious, is the 22nd district?
It must be.
Well, no, it's Montgomery County case. So this jury should not have been given that day.
Yeah.
We moved it to
It's
Cumberland.
Cumberland County.
We changed the venue.
So let's go back, since everything.
So now it is.
So. Let's go back to May. Will the Bay's case is going this time?
It's supposed to. I'm surprised when I asked Daniel back today.
Judge, I don't believe it will. I discussed this case with, Ms. Gordon Anderson. There was an order that was, I guess, entered yesterday, from a motion in January asking for medical records. that I think the Commonwealth needs and I need to see. So
Ms. Gordon Anderson, you know, are you handling the Bay's case? Come on up here. What's the story on the Bay's case?
We had it set for trial and Mr. Pennington had just brought to mine and Mr. Hunley's attention that there were some pharmacy records that we had, I think that we had tendered an order back maybe in January. And he said that it had just been entered past maybe 2 days ago.
yesterday.
Okay. And, but like I said, I just saw the order. He just showed it to me out in the hallway a little bit ago.
When are they both? If they mailed out from the pharmacy, then your history or status. And you checked on it. They're just the pharmaceutical.
Yes.
Which and again, I don't want to speak on the Commonwealth's case, but my understanding was the pharmacy records were what were going to lead to medical records, which was why we set the trial out in May back in January. So, yeah, I don't know where you're at on discovery. I don't want to speak for you, but I mean, Judge, it presents an issue of
We are needing the records.
Yeah, I think
know,
we
the
both need the records and.
I said the prosecutor, we are needing the records for our case.
So you think you'll get the records this week?
That's what Mr. Stockton believes if it got sent out yesterday. And I know I did see on the order that the pharmacy was on the distribution, so.
We call, and we call pharmacy. Oh, I thought you called it. Rollins 14, same probably the first week before they're available.
And Judge, just to note, and again, I don't know what volume of records these are gonna be, but the request was to go back to April of 2018. So I expect a lot of records.
One thing you could do, Your Honor, and I don't know if the court wants to do this, I had a conversation with Ms. Costello yesterday on the Raymond Oliver case, which set for June the 10th in Cumberland County, June 11th and 10th. I think that case will either be settled or I want to ask the court if it will be allowed to mediate it. And you could put Bays in June. That's why you have that date, that give everybody time to make it.
I'll do that. Yeah, I have no objection to him.
I'll give you all extra money. Bays, he's still.
I agree.
Yeah.
Well, she didn't have everything.
Okay, that opens up the days. The 14th and 15th, is that correct?
Yes. Yes, I would try Mr. Mark, either one of those, that was big man. They know this.
Let's do it on the 14th. And district court here on that day, like,
Yes.
let's do it on the 15th.
You don't even get this thing in time quick. Mark,
Okay, Hannah Murphy. Carlo versus Hannah Murphy.
That's all.
That's not what
Carlo versus Hannah Murphy. Are you Hannah Murphy?
Yes,
You born in 2001?
yes,
Last four digits, social security number 5960.
yes.
We're here for a pretrial conference in 24 CR 0016. What does the Commonwealth have to say?
We have a pretrial diversion, please.
A motion has been tendered, ma'am, that says you wish to plead today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified
Yes.
in this guy? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with this advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? You believe you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Or I can accept the plea, I need to know that you understand those rights. You have a right to not testify against yourself, and make you say anything, a right to speed trial. The jury, rather be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify. Gives you the right to produce evidence, the right to call witnesses in favor. Right to appeal this matter to a higher court if you lose, and right to apply the Commonwealth to prove beyond reasonable doubt to guilty charge. Can't you understand that you're guilty, give up those rights? You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I have to accept the recommendation. If I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. I understand there's going to be an offer of pretrial diversion. I'm going to qualify you for that right now with some questions. Have you previously been diverted in the last 5 years?
No,
Have there been any felonies in the past 10 years?
no,
Are you currently on probation?
no,
You understand that you fully complete the diversion agreement, the charges will be dismissed.
yes,
You understand that if you do not fully complete diversion, you will be brought back before the court and will schedule sentencing. Understand that? Can you move to the law? What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to unlawful imprisonment first degree, the defendant shall receive a sentence of 2 years, serve 30 days on home incarceration with the balance pretrial diverted for 2 years, supervised. The defendant shall be hooked up on home incarceration within 24 hours after entry of plea. The defendant shall have no contact with the victim. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner with the laws of the Commonwealth and the holding agency.
So what you agreed to, is that your understanding?
Yes.
Are you pleading guilty because you didn't commit the acts charged in the indictment that's amended?
yes,
You do so of your own free will.
yes,
Knowing the constitutional rights to sue your desire to proceed with the plea and allow the court to fix your punishment. Is that your signature on the motion there?
yes,
Okay, I'll accept the agreement. You realize if you violate the terms of this, you're brought back in and out of the vote, you'll be a convicted felon. This could be used to enhance the future. You understand that?
yes.
And you need to, I'll sign the order. You need to meet with the probation and parole officer there. He'll tell you what kind of information, okay?
And Judge, just briefly as a point of order, Ms. Murphy also executed a waiver of dual representation. She's a co-defendant with Mr. William Willis, who will also be pleading guilty this morning.
It's been explained to you that the charges against you, cases could be adverse to each other, but you agreed to waive that. Is that right?
Yes.
Thank you. Lloyd Owens. Commonwealth versus Lloyd Owens, 24 CR 0004. Are you Lloyd Owens?
Yeah.
Born in 1956.
No, 59.
You're about 3 years off for this belt. Your last 4 digits of social security number 8020.
Yep.
You're on a pretrial conference. What does the Commonwealth have to say?
Well, I don't
Mr.
know.
Stockton, if you come on up.
If we've made any progress, if there's a chance of making progress, I'll have one more negotiation there. We need to set it right.
I think there's some fluidity on the other side, so let's have another.
What's the charge?
Strong is charged with wanton endangerment, point of running 2 different people on the same day, so either we need to get it resolved or get a trial date.
Agreed.
Well, how do you resolve it?
Well, evidently it was a family dispute. Mr. Kraus talked about filing suit against 2 people and we decided not to now. That was one situation that had come up. And then
We've heard that you're going to be contacted. I don't know.
well, I know what the victim's last told my victim.
I understand. And if, we'll just have to see.
So,
That was the last.
Well, it causes me concern. These people are going to change their story because under threat of a lawsuit.
Yeah.
I don't really go for that.
Well, as usually happens, there's always something going on when there's a dispute.
It's a family dispute, Your Honor, and
Which often ended in deaths when people pull out guns and shove them at each other. Well, we'll schedule it for, let's schedule it for your negotiation day.
We're gonna call a resolution next motion day. I'll ask for a trial.
Well, and I want to be careful about, I want to be kept fully informed about the resolution, and I probably want the victims up here themselves.
I'm not gonna, unless they sign off on
Well, I know.
it. Not in this case.
Yeah, I know, but what I'm saying is, I want to talk to them.
Okay. We can have it.
Okay, June the 7th and June the 13th. Thank you.
Wait, let me ask.
Timothy Perigin. Commonwealth versus Timothy Perigin. 23 CR 0064. Are you Timothy Perigin?
Yes, sir.
Born in 1970.
Yes, sir.
Last 4 digits of social security number 7334.
Yes, sir.
Okay, what we got?
The fence at the vote was suppressed. We got one witnesses here and the other one's down the ground here.
Okay, we'll pass that to the end of the document.
Thank you, Judge.
Anthony Richardson. Anthony Richardson. 23 CR 0064 Commonwealth versus. Excuse me, 24 CR 0020 Commonwealth versus Anthony Richardson. Are you Anthony Richardson?
Yes, sir.
Was you born in 1998?
Yes, sir.
What is your solo? Last 4 years, social security 1777. Pretrial Congress was a Commonwealth episode.
We have a felony plea, Your Honor.
Motion contended ensures that Susan Houston are plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Sir.
Are you the same person just identified in this indictment?
Yes, sir.
Judgment is declared in your place today.
No, sir.
Have you discussed this charge with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Have you reviewed the evidence the Commonwealth has, are you fully informed?
Yes, sir.
You have certain rights in Kentucky, United States Constitution, understand that you do not have to enter a guilty plea. You have a right not to testify against yourself. No one can make the same thing, right to speak trial, but jury right to be represented by counsel to jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor and process issue, appellate attendance. And right to appeal this matter, higher court if you lose, right to call the Commonwealth plea on reason without the guilty charge. You understand that by entering guilty plea, they give up those rights. I may consider the Commonwealth's recommendation, I may apply anything sense of the law. Don't have to accept it. Prior to accepting your recommendation, I will wait a pre-sentence investigation report done by probation and parole. In the event that they will not accept Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea, seek the trial. Understand that? Step over to the left a little bit. Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, Mr. Richardson will plead to the amended charge of possession of controlled substance first degree, receive a sentence of 3 years, probated for 5, supervised. He'll be residing in Tennessee, so his probation will be transferred to that state. Receive credit for time served, obtain gainful employment, do community service, and all evidence in this case be destroyed and pay court costs at discretion of the court.
How much?
Back.
Costs $155. Is this what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
I pick up some. Yes, sir.
You're doing so of your own free will.
Yes, sir.
Knowing your constitutional rights is if you desire to waive them out in court to fix the punishment.
Yes, sir.
Okay, you understand that but after entering a guilty plea today, in future convictions, a felony could be enhanced as far as your aim to penalty, persistent felony offender law. Understand that?
Yes, sir.
That's your signature on the document.
Yes, sir.
I'll accept the agreement, order pre-sentence investigation board to be done by probation and parole. When you come back, on, June the 13th, sentence. William Stearns,
We'll put him in CIC.
Johnny Stevens, Commonwealth versus Johnny Stevens, 18 CR 0059. Are you Johnny Stevens?
Yes.
Born in 1977.
Yes.
The last four digits of social security number.
3940.
Okay, you're here on case 18 CR 0059. What was a Commonwealth episode?
Well, the last time we were in court, the court basically said you had to pay in full. He'd be all right if he didn't get the vote. He's paid $530 out of $900.
Well, that's pretty good effort. I want you to be back here in court on June the 13th and the rest of it paid in full by then, okay?
Thank you, Judge.
Thank you. Kaylee Swift, so. GH Silent. Hey, say your first name.
Haley.
Commonwealth versus Kaylee Swift. 24 CR 0017. Ms. Swift, were you born in 2001?
Yes.
Last four digits of social security number 2547.
Yes.
Your day for the pretrial conference, what says the Commonwealth?
Judge Holmes, represented by Mr. Wittenberg, and we called, no.
That's correct. Mr. Wittenberg represents her. And I guess he should have told her to be here at 1 o'clock and made arrangements because Mr. Wittenberg's gonna be here at 1 o'clock on, his other case, Swift, Cody Smith. But he didn't tell you to be here at 1.
Yes, he did. I just wanted to make sure I showed up so nothing happened.
Okay, that's a good idea.
Yeah.
See you at one.
Oh, thank you.
Candace Tweed.
Very.
Commonwealth versus Candace Tweed, 23 CR 0058. Are you Candace Tweed?
Yeah.
Born in 1997. Last four digits of social security number 2464.
Yes, sir.
Here today for a pretrial conference represented by Mr. Wilkerson. What does the Commonwealth have to say?
We have a pretrial diversion agreement, Your Honor.
Just keep it. Okay. I'll let you. Motion been tendered, ma'am, says you wish to be pleaded today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Just pleading freely and voluntarily given.
Yes.
Are you the same person just previously identified in this case?
Yes.
Is your judgment impaired today?
No.
Can you discuss this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
You believe that you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to be assured that you fully understand those rights. I'm going to go down through them at the end. I'm going to ask if you understand.
Okay.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial of jury, right to represent the counsel of the jury trial. Right to confront, cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose. Right to part of the Commonwealth prove beyond a reason without your guilty charge against you. Understand, but enter your guilty plea today. You give up those rights.
Yes.
Now, I may consider the Commonwealth's recommendation, but I may plan your may apply any range of sense applicable. I don't have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher penalty, you have the right to withdraw your plea and go to trial. You understand that?
Yes.
I understand there's a pretrial diversion agreement that's about to be announced. I'm going to ask you a couple of questions before that statement. Have you previously been diverted in the last 5 years?
No.
You have any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand if you fully complete the program, the charge will be dismissed pre-trial diversion, you get your record expunged. Do you understand
Yes.
that? You understand that if you do not fully complete the diversion, You'll be brought back to the court, we could schedule a sentencing, which, sentencing, you'll be a convicted felon, that can be used against you in the future to enhance sentences, you understand that?
Yes.
Okay, you'll step to your left, please, Mr. Stockton. What is the Commonwealth's recommendation, ma'am? You listen very closely.
Your Honor, she has two possession charges. She'll plead guilty to each for a sentence of 3 years concurrently for a total of 3 years. Pretrial, the verdict for 5 years supervised. She'll receive credit for time served. She'll obtain, maintain gainful employment or do 30 hours community service. The evidence in this case will be destroyed. She'll pay court costs at the discretion of the court.
Yeah, now what, I've noticed there's not anything there that says that she has to do whatever the clinicians say or anything.
It's probably just an oversight on our part.
Yeah, she'll have to agree to work with the clinicians, there at probation parole if they think that you have any addictive tendencies or anything, you'll need to do that. Will you agree on the record to do that?
Yes.
Okay. Are you pleading guilty of these acts as amended because you did commit the acts?
Yes.
Okay, you're doing so of your own free will,
Yes.
knowing your constitutional rights is still your desire to give up those rights and allow the court to fix your punishment within the range that you agreed to.
Yes.
Is that your signature on the document?
Yes.
If you'll hand that back over to Mr. Stockton, we all just kind of pencil that in there about, initially about the clinician thing.
John Brad. Step out there and call it. He's out here.
Okay.
What kind of drug was this, meth?
They had hydrocodone.
Some people are required to go to drug court. They didn't require you, but I'm gonna tell you, you need to be very frank with the probation parole officer. If you feel yourself headed in a direction where you are inclined to get wholesome meth or hydrocodone or anything, again, you need to report to them. Be preemptive. You understand what I'm saying?
Yes, I do.
Don't get caught doing it. You got a problem. We're in a problem-solving business here. People work for us. Yes, okay? Probation parole officers over there. What are the court costs? Need some time to pay that?
Yes, please.
Okay, you can pay $30 for 30 days from today and $30 every month you get it paid, okay?
Okay.
Thank you.
Yes.
Candace Tweedy.
That's me.
Well, I've already sentenced you. Angela Wallace,
Thank you.
you get sentenced twice today. Angela Wallace, excuse me. Are you Angela Wallace?
Yes, sir.
Okay. Were you born in 1972?
Yes, sir.
Last 4 digits, social security number 7871.
Yes,
I mean, 24 CR 005 for pretrial conference. What we have?
Well, we don't have anything because I don't know, was it last month you was appointed on this case?
That's correct, Judge, and just to kind of take the lead, I've discussed with Ms. Fields, Ms. Wallace also has a case out of Wayne County.
What's the charge here?
This is a trafficking case. She also has a trafficking case out of Wayne County, so we're trying to work to resolve the
What's the
cases in
crime?
conjunction.
65 grams, better than my, than half ounces.
I don't care what they do over there. You know, people do whatever, let's set it. You want a negotiation date or a trial?
I don't care to do one more because this is the one that Mr. Cross had for a while, and we were finally withdrew because it had a conflict, so I don't.
Okay, June the 7th, 9 a.m. for negotiation. And June 13th to announce a settlement of the case or set a trial.
Yes, Judge.
Thank you.
William Willis. Commonwealth of Kentucky versus William Willis. Are you William Willis?
Yes, Your Honor.
Okay, were you born in 1997?
Yes.
Last 4 digits, social security number 1336.
Yes.
So you have two cases here today, 24 CR 0014 and 24 CR 0015. What's the Commonwealth have to say?
We have a pretrial diversion plea, Your Honor.
Okay. Motion's been tendered, says you wish to enter guilty plea. Is that correct?
Yes.
Are you currently in the influence of drugs or alcohol?
No.
Is it plea freely and voluntarily given?
Excuse me?
Is this plea freely and voluntarily given?
Yes, Your Honor.
You're the same person we just identified when you came up here and the same person in this indictment, is that correct?
Yes.
Is your judgment impaired today in any way? Is your judgment impaired in any way?
No.
Have you discussed this matter with your attorney and you feel satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights in the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go down through the rights and I'm going to ask you if you have any questions, okay? You have a right not to testify against yourself. No one can make the same thing right to speedy trial by jury, right to be represented by counsel at the jury trial, the right to confront and call to all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter at a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you guys are charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
And we consider the Commonwealth's recommendation, I may apply any range of sentence provided below. I don't have to accept the recommendation. In the event that I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. I understand it's a pretrial diversion that we recommend, so I'm going to ask you some qualifying questions, okay? Have you previously been diverted in the last 5 years? Do you have any felonies in the last 10 years? Are you currently on probation?
No.
You understand if you successfully complete the diversion program, the charges will be dismissed and you can have your record expunged. You understand that?
Yes, sir.
You understand if you not complete the diversion program, you'll be brought back for the court to decide to schedule a sentencing hearing to be a convicted felon. And that can be used against you in the future. You understand that?
Yes, sir.
Move to your left, Mr. Stockton.
Your Honor, in 24 CR 14, he'll plead guilty to the charge of unlawful imprisonment, receive a sentence of 2 years. And the charge of theft, unlawful taking less than $500, he'll receive a sentence of 12 months. Upon a plea of guilty in indictment number 24 CR 15, the charge of possession of controlled substance first degree, he'll receive a sentence of 3 years. The 2-year sentence, 3-year sentence, and 12-month sentence shall run concurrently for a total of 3 years. He'll serve 30 days in jail with the balance pretrial diverted for 5 years supervised. The defendant shall be referred to the SSC and follow all recommendations. He owes $207 restitution to the victim. In this case, he'll pay that upon entry of the plea today. Restitution shall be dispersed in accordance with the restitution order. He shall have no contact with the victim, receive credit for any time served, obtain gainful employment, or do a minimum of 30 hours a week. The evidence of the drug case will be destroyed, and then he'll pay court costs at discretion.
What's court costs? Court costs are $155. I'll let you make your first payment. Has he made the restitution payment today?
Well, Judge, what we were discussing is he has posted, I think it's in his name, a $20,000 cash. There's a $20,000 cash bond, so.
Whose money is it?
It's Robert Jackson. It'll be my
If it's not in his name.
it'll be my stepdad's grandson. So
He's got to pay the money today. 200 and whatever dollars, and then the court costs is what?
155.
So you got a total of $355.
Well, clerk's fee.
Yeah.
can that be taken out of the bond or?
Yeah, all of it can be taken out of the bond.
Okay.
Okay.
Whoever
Whoever does it has
That's-
to,
I
they'll
guess
have
that's
to
what
do
you-
it. So that needs to be paid by close of business today.
I can go there. He lives in Wayne County. He just had to come down here.
And Judge, similar to Ms. Murphy, this is the co-defendant, so Mr. Willis also executed a dual.
You and Ms. Murphy agree to have the same lawyer, is that correct?
Yes, Your Honor.
Okay, you need to talk to probation parole officer.
Is he not going to custody for 30 days?
Oh,
Is that part of the deal?
yes. What,
They take him into custody. Okay, thank you. Okay. Cameron Wright.
Yeah, sure.
Commonwealth versus Cameron Wright, 24 CR 0021. Are you right?
Yes, Your
You're
Honor.
born in 2002.
Yes, Your Honor.
That's 4 digits, social security number 4725.
Yes, Your Honor.
Different pre-trial comments. What does the Commonwealth have to say?
We have a plea, Your Honor.
Felony or diversion?
No, it's, or
Motion has been made, Mr. Wright, says you wish to enter a plea today. Is that correct?
yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
No, Your Honor.
Plea for any longer urine?
Yes, Your Honor.
Are you the same person that we just identified when you came up here in the indictment?
Yes, Your Honor.
Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
Do you view the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at jury trial. Right to confront and cross examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter. How important it is. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand it, but enter a guilty plea today, you give up all those rights. You understand that?
Yes, Your Honor.
Consider the Commonwealth's recommendation if I decide to impose a harsher sentence. You will have the opportunity to withdraw your plea. And I'm going to qualify you for this pretrial diversion first before we go any further. Have you previously been diverted in the last 5 years?
No, Your
Have
Honor.
you felony convictions the past 10 years?
No, Your Honor.
Are you currently on probation?
No, Your
You
Honor.
understand if you successfully complete the diversion agreement, you will be dismissed. Charge will be dismissed and you can have your charges expunged. You know that?
Yes, Your Honor.
You understand if you don't successfully complete, you'll be brought back to the court, pre-sentence investigation report will be asked for to be sentenced to be a convicted felon that can be used against you in future to enhance sentences. You understand that?
Yes, Your Honor.
Step to the left, Mr. Stockton, what's the Commonwealth's recommendation?
Judge, if I may, just very briefly, there will also be a DUI guilty plea in this. He's executed the form. I didn't know if you wanted to go through that.
Yes, just come back around here. You understand it, but entering a plea to DUI, that's enhanceable too. If you get other DUIs in the future, the penalties will be enhanced
Yes, Your
for
Honor.
an extended period of time, though. So you understand that?
Yes, Your Honor.
Okay, now step to the left.
Your Honor, Mr. Wright will plead guilty to wanton endangerment, first degree, receive a sentence of 5 years, serve 30 days in jail with balance, pretrial diverted for 5 years, supervised. He'll plead guilty to operating a vehicle under the influence, first offense, aggravating circumstances. He'll receive 4 days in jail, and those two sentences shall run concurrently for a total of 30 days. He'll receive credit for time served, obtain gainful employment or do community service, agrees to have all evidence in these cases destroyed, and he will pay court costs at the discretion of the court.
Is that what you agreed to?
Yes, Your Honor.
What's the court cost?
155.
Look, there's DUIs here too.
There's a $200 fine, $425 DUI service.
It's $960 for the, $1,115.
Okay, you can pay that, start at $50 a month.
Yes.
Okay, starting 30 days from today. Okay. Now, is that your signature on there?
Yes, Your Honor.
Okay, I'll accept the agreement, signed version. Was he served some time in jail, Mr. Stockton?
Yeah, my understanding is he's probably got it all
Yeah, he
served.
did have credit for time served.
Yeah, he's
That was the.
30 days now. He got jail credit, so we probably need to check that. I know the other gentleman that didn't have any, I don't think. At least Mr. Pennington told me he had it in. I don't know.
I don't know,
The exact dates.
I don't know the exact dates.
Let me call and find out real quick.
Yeah.
Was you, White, was you Clinton County?
Yes. Started, I mean,
I was able to.
Where are you working?
Let's find out.
Yeah.
Hey, Dennis, this is Carson. Can you tell me how many days jail credit Ken McBride had on case 23 CR 21 or, yeah, or in court? I mean,
Dare County, are you on the line?
Hey, James, you make that motion already.
Daryl
Yes,
Platt?
sir, Honor. We're here.
Okay, thank you. Commonwealth versus Daryl Platt. 24 CR 001. Where'd you find out about his
Oh, I think
days?
they're still waiting. My representative.
We'll come back to it.
hey, this Carson.
This is Cumberland County case number 24 CR 0015, 24 CR 0023. We're here today for the purpose of sentencing. Ms. Costello, are you on the line? You represent Mr. Platt, you represent.
I represent Mr. Platt.
Okay, your attorney is, never mind. Your attorney is here in the courtroom, Mr. Platt. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Is it substantially correct?
Yes, Your Honor.
Okay. Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
While pleaded guilty to indictment number 24 CR 115, possession of controlled substance, methamphetamine, he received a sentence of 2.5 years. While pleaded guilty to indictment 24 CR 0023 for charge of possession of controlled substance, first degree methamphetamine, he shall receive a sentence of 2.5 years. The 2.5 year sentence shall run consecutively for a total of 5 years, probated for 5 years. Supervised, defendant shall enter a complete long-term treatment facility scheduled through DPA and agreed order between the parties. Receive credit for time served, shall obtain gainful employment or do 30 hours of community service until then. What are court costs this case? I'll make it $150. You know, combine it for the two of them, you can pay it $30 a month, start paying 30 days after you get out, okay?
And Judge, just as a point of order, Mr. Platt, as I've already tendered a bed letter to Madam Clerk. He's set to go to ARC tomorrow if the court be inclined to sign a release order.
I'll sign a release order and let him out in the morning when he's transported. Okay?
Thank you, Judge.
Well, let's go back to James Craig. Is James Craig there?
Yes, Your Honor.
Commonwealth versus James Craig, 22 CR 0042. Oh, yeah, this is a Cumberland County case, meeting by agreement. Zoom in Clinton County. What do you have, Mr. Stockton?
Judge, if I may, this was my motion. It was a motion for review. Mr. Krieger was taken into custody last week in Cumberland County. He has since been referred into specialty court in Cumberland County. Judge, I found out since meeting with him that he has a severe groin and testicular issue. He's had some abnormal lab testing and imaging.
I don't really care to put all that on.
I was gonna say,
record.
Judge.
I don't care if you tell me,
Okay.
we're broadcasting this. Okay, wait a second. You step away and talk to Mr. Stockton.
And
Wait a second.
I understand.
Okay.
And Judge, what
Why
we're,
did I take him into custody last?
You took him into custody because he violated his pretrial diversion. He had multiple marijuana tests. He tested positive for meth. You took him into custody so he could go into drug court. I've talked to Mr. Murphy. He's assessing him next Wednesday. I want him to be able to go to his doctor's appointment. I don't know if the court wants to release him after the assessment on home incarceration, and go on his doctor's appointment or.
I'll put him under the curfew. Just put him under. Mr. Craig, you think you can stay off the dope and behave yourself, so we let you go to the doctor till you come back in?
Yes, sir.
Okay, well, let's put him on, he's a probationer, okay?
Hey, Mr. Garner.
You will keep him, I'm putting him under curfew, keep him at his house, okay?
All right, I'll tell Mr.
Are
Garner.
you gonna release him?
I'm gonna release him today.
Well, now he needs to contact Mr. Murphy about the assessment, make sure he's there to be assessed.
When is that?
Mr. Murphy has it scheduled for next Wednesday. He thought he was gonna be in jail, so he needs to make sure he makes arrangements with Mr. Murphy to be.
You understand, you need to call Mr. Murphy at the drug court.
Yes, Your Honor.
Okay, and so you'll be there next Wednesday for your assessment. I'm gonna let you, when's your doctor's appointment?
It is May the 9th, sir.
Day after he's supposed to meet with Mr. Murphy.
Why am I letting him out before? He's not gonna see his doctor till then.
That's my question. Yeah.
Unless,
what?
Jason requested a hold.
Okay, you want to hold him till the assessment?
Yes, and then release.
and I have no objection.
That way-
Judge. That way he'll be
Get out
there.
the
and-
Okay, that'll be fine. We'll hold him to the assessment then.
So you'll get out on Wednesday, James.
Thank you.
Thank you.
Thank you, Judge.
Adair County, is there anybody else in Adair County?
No, not that I know of, Your Honor.
Okay, thank you. Y'all are excused. Green River Correctional Institution never came on.
Judge, according to the jail, he had 18 days in custody.
And Judge, I discussed this with the Commonwealth. I'll make a motion to let Mr. Wright serve the rest of that on home incarceration. He is working full time.
You know, I don't have anything against Mr. Wright, but everybody else that gets in these situations serves their time. So he's gonna have to serve his 30 days, just like everybody else does.
24 days?
Yeah.
12 more days.
Okay, is Green River Correctional Complex on there? Not, could you contact them, see if you have?
Your
any-
Honor, I will send them an email again. I've spoken to them this morning. They said they had the link, so I'll email it again.
Okay, email them again, and then North Point Training Center,
Mother.
North Point Training Center, are you on there? That's a DPA case too. Are y'all on there, North Point? Chance Phillips is at North Point.
That's Green River, sir, if you can hear me, hold on.
You need to turn your camera on if you would.
That's what I'm working on, sir, I'm sorry. It wouldn't let me till just now.
There you go. Commonwealth Kentucky versus Daniel Moreland, 08 CR 0079 and 08 CR 0070.
Yeah.
Oh, I thought we were at North Point. Sorry. Green River now, Benjamin Clavel. 22 CR 0047. You Benjamin Clavel,
Yes, sir.
born in 1986.
Yes, sir.
Last four digits, social security number 2415.
Yes,
You're here today for sentencing. If you had an opportunity to look at the pre-sentence investigation report done with probation and parole,
Yes, sir.
is it substantially correct?
Yes,
Your Honor, the only corrections that we saw were his jail credit was only listed as 3 days because the majority of his credit was going to his state sentence he was previously serving. But he believes that it should be more like 2 weeks from July 29th to 8/12. That was prior to him being revoked. So if probation and parole could just look at that.
What happens is when the warrant is issued, when they put him in jail, he should have got that credit on the other case, but I'll check it. I'll check it.
Thank you.
Okay. Is there any other reason this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to manslaughter, second degree, and PFO, defendant shall receive a sentence of 15 years. Upon plea of guilty operating under the influence, he shall receive it, and PFO, he shall receive a sentence of 10 years. Upon plea of guilty operating while revoked or suspended for thirds or subsequent, he shall receive 10 years to 15, and the 2 10s shall run concurrently for a total of 15. To serve the 15 years shall run consecutive to Clinton Circuit 21 CR 0089 and Clinton Circuit 21 CR 0088 and Wayne Circuit Indictment 17 CR 0054. He shall forfeit $337 to the Commonwealth to be dispersed in the forfeiture agreement. And I will waive the court costs since because of the length of the sentence, okay?
Thank you, Your Honor.
Thank you very much. Thank you, Green River, for your cooperation. You'll be excused. Now, did North Point ever get on there? If not, we'll go, is Wayne County on? There's Wayne
Your
County.
Honor, before we go on Mr. Moreland's case, is Mr. Pennington representing him or is DPA got a
post-conviction counsel. Because I filed a brief, I've never received a brief on Mr. Moreland's case. You ordered last month that they were supposed to file a brief within 15 days
On what issue?
on the issue about resentencing Mr. Moreland or what options he was gonna take. And it's a pretty serious case. And I just think if he's not ever gonna be on Zoom, somebody needs to do a transport order and have him down here next motion day.
Let's just do a transport order. Have him back down here on,
Well, we need to clarify who's representing.
it says DPA. What do y'all know about that?
Where's Mr. Pennington?
Do a transportation order, have him down here.
If he's the one representing, I'm not sure.
Ms. Costello, do you know who represents him?
Your Honor, I was, as Mr. Stockton was talking, I was looking back into my contacts and I believe that post-conviction was representing Mr. Moreland. I think they may have appeared at one point, so I will reach out to them and let them know that it's been reset and that he's going to be transported.
Could somebody contact me, make sure that he's got representation before for entering appearance next month? Because
Yes, I will. Yes, Mr. Stockton, I'll communicate and I apologize for the confusion.
Well,
Excuse me.
I understand. But nothing's going on in this case. It's been like 2 months.
Well, if you'll prepare an order direct, do you know anything about who's representing Daniel Moreland?
Okay.
So that, you're excused, Ms. Costello.
Okay.
My apologies, Judge, I was
Let's
printing
do
off the
it.
opinion.
Evidently, we're gonna have trouble with North Point Training getting on the line. So we'll do transport, we're gonna have him here on June the 13th, where Mr. Stockton mentioned in passing that there were briefs due on this.
Well, the issue that we had got into, very, very briefly, Judge, and I'm talking on page 14 of the opinion, the Supreme Court said, given that we have held this issue is one of illegal sentencing and is a failure to follow statutory parameters when probation is available, we hold the remedy in this case is remand for resentencing. This case is more analogous to Fawn than it is to Planahan. The solution also obviates any claim by either Moreland or the Commonwealth that they have been deprived the benefit of their original bargain because both parties, along with the trial court, may now seek a new bargain on how Moreland shall serve his sentence, including, if agreed to by the parties, a new period of probation in conformity with the statute. I think Mr. Stockton was taking the position that this was only sentencing. I was taking the position that Mr. Moreland is entitled to benefit of the bargain, or at least a negotiation.
Well, you can negotiate unless Mr. Stockton doesn't want to negotiate, and that ends a negotiation.
Right, and I think
that seems the way we're headed, Mr. Stockton.
It does.
We've settled negotiation aspect of it. Do we need a new pre-sentence investigation report done on this?
I would say,
It's the original sentence, my understanding.
well, no, he's been out.
I'd say you will.
So yes.
Yes, sir. Yes, sir.
But in that issue, he's also a sexual offender, so we have to have another.
I think he's gonna have to have the special, you're correct. So, I mean, Judge, I know we're getting into a lot of when I'm sure Mr. Moreland will be agreeable to probation with some strict terms, and that takes care of the situation. Because with this being a case of first.
New sentence, new bargain, because.
Look, it's a little early. He said he didn't want to negotiate, and you're trying to negotiate. So what I want is a pre-sentence investigation report. So we're on the record, it says you asked Commonwealth if they wanted to negotiate. They said they don't want to negotiate, that they want him to live up to the agreement that he signed and to be resentenced. So I'm going over a pre-sentence investigation report to be done by probation pro and a sexual offender report to be done, but I'm going to put it out a little while. I'm gonna make it on July the 11th. That'll give him time to do somebody do the offending, okay? And I want a transportation order for July the 11th, having.
Yes, Your Honor. Thank you.
And on July the 11th, since he was not here today, I want you to make the same arguments about the case that you did today, so he'll have present to be here and being completely involved. The only thing I'm doing today is setting a date in order for pre-sentence investigation report. I'm not making any determinations about anything else.
I understand, Judge. Thank you.
Wayne County, are you on the line? Wayne County? I see you there. There you go. Commonwealth versus Virginia Catron. Are you Virginia Catron? Somebody needs to turn their microphone on. There, please.
Yes, I am.
Okay.
Maybe.
Thank you so much.
Where's the file? Virginia Academy.
Ms. Catron, we're here today on 23 CR 0045. Were you born in 1985?
Yes, Your Honor.
Last four digits, social security number 5809.
Yes.
For a probation revocation, what does the Commonwealth have to say?
Your Honor,
You
Ms.
get
Catron-
behind this podium so I can hear you.
Ms. Catron failed a drug test, or admitted use. She went into treatment on her own, then she was made to go, she didn't complete, she was made to go to Cumberland Oak by probation and parole. She was discharged from there when she said she couldn't do the program. And then when she got back on April the 7th, she was positive for oxycodone and is living with a convicted felon.
You want to stipulate?
Judge, we'll stipulate.
Okay. You will make any argument as to why she shouldn't be revoked?
Judge, this is substance abuse, and I understand Virginia had some problems with the treatment she went into. I spoke with her this morning, and she had actually asked for specialty court and drug court to have some of the tools she needs to succeed. It's, she didn't pick up any new charges. Again, I understand you can't be on probation using.
Yeah.
Problem I have with drug court, I need to find out if she is
Eligible to go to and be assessed for the specialty court is where she's gonna be living, because her current living arrangements are not acceptable if she goes into drug
Now,
court.
Jesse, she was just in a relationship.
Okay,
She
I
was
just
living
wanna
with
make,
her.
okay, well, I made a mistake. As long as she's not associating with any convicted felons and wants to go
Well,
into.
she was
special-
associated. You said you was in a relationship.
Yeah, so,
Ms. Catherine, you understand that you cannot be in a relationship or association with convicted felons. You understand that?
Yes, Your Honor.
Okay. Well, if y'all will, I'll sign an order referring her to drug court. See if you're eligible. Okay, and once they do referral and vote you, I'll let you out for an orientation if they let you in. But now, Ms. Catherine, ball is in your court. It'll take a little while to get you into drug court if you're eligible, but you're gonna have to work real hard at it and comply with what they say. You think you can do that?
Yes, Your Honor.
Okay, well, that's what we'll do then. They'll be over in contact with you about interviewing you if you'll submit an order on that. Commonwealth versus John Brown. Commonwealth versus John Brown. John Brown.
Your Honor, he has more significant charges than Wayne. He has a possession here.
There it is. Commonwealth versus John Brown.
Yes.
23 CR 0059. Are you Mr. John Brown?
Yes.
Born in 1979.
Yes.
Last four digits, social security number 2532.
Yes.
Okay, Mr. Stockton, you were speaking about Mr. Brown. weren't you?
Yeah, he has more significant charges in Wayne County. He has a court date on June the 4th. This is a possessing charge here. I would request that we see what happens.
Let's go to July the 11th. When is his court date over there?
June 4th.
Okay, let's go to June 13th.
Yes, Your Honor.
And I'd say have him on June the 7th for negotiation and June the 13th. Both of those are after his court date. Your attorney will be in contact with you. Mr. Brown, Wayne County, do you have anybody else that desires to speak to the court?
There's nobody else.
Wayne County.
There's nobody.
Wayne
else.
County is excused. Let's go to Russell County Detention Center. Don't see them on there. Will somebody call over there to Russell County, see if we can get them on? Okay, Clinton County Jail.
You wanna do the hearing first, John, or do the Clinton County Jail?
Well, let's do the hearing first. We've got a suppression here. Clinton County will be with you in a few minutes, and then we'll try to get on with Russell County. What's the style of this case?
It's Commonwealth of Kentucky versus Timothy Perigin, 23 CR 64.
Okay, Mr. Perigin has previously been identified and is present in court. There's a motion to suppress. Is this a warrantless search or what is this?
I
Yes, Your
believe that's
Honor.
what they're,
You don't come around
It's an
here.
extended stop situation.
Well, tell me a little bit what your motion's about, Ross.
Ms. Fields will address it.
Okay.
Yes, Your Honor. So what we have in this case is a stop that took place for a few traffic violations. It looks like it began with an obstructed windshield. Troopers also observed his license plate to not be
Is there a
illuminated.
dog involved here?
There's not, Your Honor.
So they, search emanated from what? They say they arrested him for something?
Well, they pulled Mr. Perigin over to address the.
Okay.
Yes.
That's good. I know what it's about then.
Okay.
Okay, call your first witness.
I call Trooper Poole.
Trooper, you raise your right hand, you swear the testimony you're about to give us the truth, the whole truth, nothing else.
I do.
Take a seat, lean toward the microphone, state your full name.
Question for a long witness, Your Honor.
What?
The room.
Well, they can designate one person to stay in. It's okay. Proceed.
state your name for the record.
Brandon Poole.
And are you familiar with Timothy Perigin?
Yes, ma'am.
And did you have any contact with him on August the 16th of 2023?
Yes, ma'am.
Please tell the judge how you came in contact with him.
So, this night, Trooper, I was the field training officer for Trooper Tucker. We were both in the same vehicle. I was operating the cruiser that night. I observed this,
What time of night?
this was approximately 23:50 hours when I initiated the stop, so I observed him just a few minutes before that. So I observed, the vehicle that he was operating to have a busted windshield. And then prior to initiating the traffic stop, I observed the license plate not be illuminated. Once I initiated the traffic stop, I done the driver's side approach, as Trooper Tucker done the passenger side approach. As I walked up to the vehicle, I observed the driver's side mirror to also be missing. I explained to Mr. Perigin, he was the operator of the vehicle. I explained to him the reason I stopped him, requested his license and the vehicle documents. I requested the identification of the passengers as well.
How many passengers?
There was 3 passengers. There were front seat passenger and 2 in the back seat. They gave their IDs. We returned back to the vehicle and ran those ID cards through Post 15 Columbia. And at that time, the front seat passenger we found to have an active warrant. We returned back to the vehicle at this time. I assisted Trooper Tucker in stepping the front seat passenger out of the vehicle, making sure there was no issues with that. Once we got him in handcuffs, I stepped back around, began talking to Mr. Perigin. At that time, I'd asked him if there was anything illegal in the vehicle or on his person, and he advised that there was not, and asked him to consent to search.
At that time, how much time has passed?
I'd say approximately 5 to 10 minutes, just enough time to go back to the vehicle and run it usually takes about 2 or 3 minutes for post to give those, records back to us. Once we find someone has a warrant or something like that, we want to get them in custody as quick as possible, just because if he knows he's got a warrant, there's a possibility he could be making, a decision to do something bad. So as soon as they told us he had a warrant, we went to the vehicle and detained the front seat passenger. So I'd say approximately 10 minutes at this time.
So you've asked for consent to search, Mr. Perigin?
Him and his vehicle.
Okay. And what did he say?
He gave consent. He said there's nothing illegal in the vehicle when he stepped out of the car.
Okay. So what
When he
did you-
stepped out of the car, what I done first is just done a pat down of this person. I don't go sticking my hands down his pockets at that point. I felt, as soon as I put my hand on his left front pocket, I felt like a baggie. And before I even said anything, he said, "That's drugs." And as soon as he said that, I placed handcuffs on him, detained him at that point. I stepped him to the back of the car. At this time, there's still two people in the back seat of the vehicle. So before I even do anything further, I go ahead and step them out as well. I put them all behind the car. We're kind of in a circle at this point. I read everybody their rights. Everybody waves them around their rights. Once everybody understands their rights, I go ahead and retrieve what seemed like a plastic baggie out of his left pocket. And when I pulled it out of his pocket, he advised that it was approximately 2 to 3 grams of meth, which based off my training, it was consistent with methamphetamine. It was a crystal-like substance.
Did he give you a weight to it?
He said it's about 2 to 3 grams, and he said that he gave, I think he said $100. Yes. He said he gave approximately $100 for it.
Did he make any other statements?
Yes, so, after that, after we dealt with that, I asked if I was gonna find anything else illegal in the vehicle. And he said that there's going to be a eyeglass container with the meth pipe in it. I think he said it was gonna be, it was located, I ended up locating in front of the front seats between the driver's seat and like the console area. Once I found it, I took it back there and showed it to him, asking if that's what he was talking about, and he took ownership of that pipe. That's what he was talking about.
Okay, was there anything else located on the search?
Yeah, so at that point, he was placed under arrest. As later on, the other two that was in the back seat gave consent to search their person. I don't remember his name, but one of them in the back also had suspected methamphetamine. That he advised it was methamphetamine. He was placed under arrest as well. And then the other one did not have anything illegal on him and had a good license, so he drove the car.
Now, as far as, were the drugs sent off to the lab?
Yes,
Have you seen those results?
I have.
And what were the results?
For Mr. Perigin, the substance that was in his pocket, it was 2.896 grams of methamphetamine.
I have no other questions. Pass the witness.
Prior to the stop that took place on August 16th, were you familiar with Mr. Perigin in any way?
I was not.
So didn't know that you didn't know of any criminal history he might have had?
No, I wasn't aware of it. Not prior to the stop.
And had you received any information about Mr. Perigin potentially being involved in the sale or possession of narcotics?
Not that I recall.
So the passenger in the front seat, they had an active warrant. Could you tell the court what that was for?
I don't recall. I don't recall his warrant. I just know he had an active warrant.
Do you happen to recall if it was narcotics related in any way?
I did not, ma'am. I'm sorry.
So what circumstances led you to ask to search the vehicle in its entirety?
So based off the time of night, and there's four guys in the vehicle, it's around midnight. They're in a vehicle that shouldn't even be on the roadway. Couldn't even really explain where he was going that night. And just based off the totality of the circumstances, it just led me into asking for if there's anything illegal in the vehicle, to search for drugs or maybe any stolen firearms or anything. He gave consent. If he hadn't gave consent, I'd continue on with the traffic violations.
Did you ask him where he was going?
I did ask him, well, I knew where he was coming from, because I'd seen him leave the Junction Station, but I asked him where he was going. I don't ever recall him making sense of where they were going or what they were doing that night.
So he left from Junction Station, the gas station.
He did.
Now, when you pulled Mr. Perigin out of the vehicle, did you have any information that would lead you to reasonably believe that he was armed?
No, I did not.
Okay. When you patted down Mr. Perigin, did you feel anything on his person that felt like a weapon?
I had consent, at this point, I had consent to search his person. And as far as the pat down you're reference to was the beginning of a search. The reason it's listed as a pat down in that citation is because that's the way I'm trained. Because, you know, it's the beginning of a search, but I'm not going to for one, I'm not letting him stick his hands in his pockets because I don't know what's in there. And I'm not going to go stick my hands in his pockets because I don't know what's in there. So the search led as a pat down. It wasn't necessarily a frisk, it was just the beginning of my search based off of consent.
So you stated that when you were beginning the search of Mr. Perigin's person, you felt, what did you feel? Can you describe that?
It's just like a knotted up plastic bag. I've felt it several times. I hadn't even made a comment. As soon as I stopped my hand on it, he advised that's drugs. As soon as he said that's drugs, I pulled his hands behind his back and detained him. I didn't ask him what it was at that point. I hadn't even pulled it out of his pocket. I stepped in the back of the car. So I knew I had two more guys in the backseat of the vehicle that probably heard that because I was standing beside the vehicle. There was four of them, two of us. I immediately stepped them out. And I did do a pat down of them to make sure they didn't have any weapons at this point. I stepped into the back of the car and everybody got rid of their rights at the same time. After that, we talked more about it and he said that it was approximately 2 or 3 grams of meth in his pocket.
So when did you read Mr. Perigin his Miranda rights?
Yes. Okay, so when he steps out of the vehicle, I feel that in his pocket. He said that's drugs. I put him in handcuffs, step into the back of the car. We've got 2 guys in handcuffs in the back of the car right now. There's 2 guys in the vehicle. I stepped them out because I want to read everybody's rights at the same time. So I stepped the 2 guys out and I've got 4 guys back there. Everybody gets read their rights at the same time. I'll make sure each of 4 people understand. Everybody understands their rights. So that's fine.
Just briefly going back to the passenger who had an active warrant.
Okay.
What was Mr. Perigin's relationship to that person?
I don't know that I asked.
So you don't know if they were a relative?
I have no idea.
Okay. Did you?
I don't think they were. I think this guy was from somewhere else.
Okay.
But I don't think they were family.
I don't have any other questions for this witness. Thank you.
I don't have any other questions or any other witnesses.
That's right. Tell our other officers.
I'm not gonna call him.
So you can come back.
Oh, sorry, I didn't hear you. Sorry. He can back.
Y'all have any witnesses?
No, Your Honor.
Commonwealth need to make a statement.
Your Honor, I don't see that the stop was extended, at all. I think the officer testified, as to what they did. There was an active warrant. Well, the reason why they made the stop in the first place is because of those, traffic violations, on the vehicle. And then there was an active warrant on the passenger. They said immediately after they, got the passenger arrested, he walked over, he asked for consent to search. The defendant gave consent. From there, he patted him down. He didn't ask him any questions. The defendant immediately said what it was. He put him in handcuffs and then he read his rights. I don't see that there was any type of mistake done at all by this trooper. So I believe the stop was good and the search was good. So.
Judge, the problem here arises at the moment that the passenger was taken into custody. Mr. Perigin was pulled over for some traffic violations. There was a few things wrong with his vehicle and his license plate was not illuminated. He was pulled over and Trooper Poole identified that his passenger had an active warrant. Trooper Poole couldn't identify what that warrant was for. If it was for narcotics related activities, which could, have been important here, couldn't identify what the warrant was for, couldn't identify the relationship between the passenger with the warrant and Mr. Perigin. Now, obviously, they have some sort of friendship if they're.
He had a warrant. Does it make any difference what the warrant is for? If he's got a warrant, they're supposed to take him into custody.
Well, Judge, what I'm
Is
saying
that
is,
right or wrong?
well, that's correct.
Okay, just proceed.
The passenger having a warrant for, say, narcotics related activities may have given Trooper Poole a little
I
bit.
think that he has a right to pat down for his own safety. Person in the car, you're out in the middle of the night, you got 4 people there, you got a couple of officers. You ask somebody to get out of the car because the person's got a warrant. He pats him down, he has a right to pat him down for his own safety, doesn't he?
Well, Judge, in
Does he
order,
have a right to pat him down?
if he has reasonable suspicion that he's armed and dangerous.
Well, I mean, you could suppose everybody out's in the middle of the night. If you was out there in the middle of the night and you get somebody out of the car, you're gonna pat them down, right? I don't know, you might be more careless than that, I should. I'm gonna say, I'm gonna pat them down. Okay, so they pat him down, and when they touch it, the guy admits that there's dope in the product. Now, he didn't have to be Mirandized at that point, correct? Because nobody there, he hadn't asked the guy anything. The guy blurted it, right?
Right, but Judge, our argument is that it should have never made it that far. The traffic stop should have ended at the moment that the passenger got taken into custody, because Trooper Poole articulated no reasonable and articulable suspicion to continue the traffic stop after that point. He identified nothing about Mr. Perigin. He had no info about him. He had no criminal history that he knew about Mr. Perigin to say that in this vehicle that was owned and operated by Mr. Perigin, there was something in that vehicle that needed to be found by a search.
Okay, thank you. Do you have anything you want to respond to?
Just that, I believe after just the totality of the circumstances, the fact that there were those 3 violations, and plus after they've already found that there's an active warrant, 10 minutes till midnight. I mean, he testified that immediately after that person was put in under arrest, he walked right over and then he asked for consent. This isn't a dog search or anything. They didn't have to wait on a dog. He asked for consent to search. He immediately said yes, and that's when it started. So I don't believe there was any extension.
Thank you. Okay, if y'all want to just do short briefs on the thing within 10 days or something like that.
Yes, sir.
We'd rather you go from that.
Yeah.
But if you don't want to, we'll break.
Well, you know,
Honestly.
I don't see any issues here either. I'm just thinking there might be something that she sees that I don't. She had a consent search. She had out in the middle of the night, they pull somebody out of the car, they pat him down, the guy blurts it out. I don't see a problem. But I'm gonna give her an opportunity to elucidate a problem that I don't see. Okay? And y'all don't have to respond to it if you don't want to. I'll give her 10 days.
What's the Mr. Harrison's bond conditions? I didn't know if he was on a curfew or being tested or anything.
Sure.
Everybody's on curfew. We have a trial scheduled.
No, I was gonna set it when we get this, so. Because this is, Mr. Perkins been in specialty court, there's several run-ins with, he knows not to be using lead and having that much on.
He's subject to drug testing, if you wanted to test it, and then her.
So that you can random drug tests in a curfew. You can do 10 days. Give me something in 10 days.
Yes, Your Honor.
And we'll be here on June the 13th. And have him, just out of abundance of caution, have him there on June the 7th for negotiation. Okay, thank y'all. Let's go to Russell County. Are y'all on there now? Luther Connor, are we on at Russell County? Russell County, you turn your camera on, please. Russell County, will you turn your camera and microphone on, please? I say Russell County. Somebody come over there for me.
Hey, Bill, can you tell them to turn their mics and camera on? We can't hear them or see. All right, that's fine.
Clinton County, if you're on the line, you can turn on. If you can't get Russell County.
Russell County said they was turning theirs on.
Okay, let's go to Russell County. Yeah, Russell County. Commonwealth versus Luther Connor, please. Are you Luther Connor?
Yes,
Okay, and you're here today for sentencing in 22 CR 0001. Mr. Connor, were you born in 1977?
yes,
Last four digits of social security number 5220.
yes,
You had an opportunity to look at the pre-sentence investigation report done by probation and parole. Have you seen the pre-sentence investigation report done by probation and parole? Have you reviewed it?
Luther, that was a document on my phone you looked at.
yeah, yes.
Counselor, you reviewed it with him.
Yes, Judge.
Was there any reason why he shouldn't be sentenced today?
No, Your Honor.
Okay, previously, this gentleman had been pretrial diverted, 2 years pretrial diverted for 5 years, and that was voided on April the 11th, 2024. He shall be given credit for time served and be sentenced to 3 years.
You're not gonna have another motion on him, if that's all right.
That'd be okay.
He was arrested back in 2020 by Fish and Wildlife, and they seized some substances along with.
Oh, no, that ain't, I wasn't arrested by Fish and Wildlife. I've never been
That's-
arrested by Fish and Wildlife.
Okay, so we've got the wrong Luther Connor.
Yeah, I mean, that ain't me. I've never been arrested by Fish and Wildlife.
Okay, well, I'll correct myself.
Okay,
Wrong Luther Connor, maybe Hoppy.
He's probably was also there.
okay, thank you, Mr. Connor. Kevin Haddix is next. Okay, we have Kevin Haddix here.
Yes, sir.
Okay, what do we have here? We have a 202A hearing.
We did, I filed a petition. As part of the 20 live.
And we're all in the process.
Well, if they either will stipulate or we need to have a hearing, I need
I
to.
don't stipulate.
I would be willing to stipulate. I think Ms. Patterson just got the appointment, but I can't
You
speak for
have
her.
no reason why you shouldn't stipulate.
Judge, I don't know a lot about this case. I only received the paperwork on Monday. I have not met with Mr. Haddix or anything of the sort.
I don't know if you want to set it for later this month, that's another county, we'll do it next month.
But she won't be available later this month.
Okay.
I guess after she leaves, if we wanted to do by agreed order, or that would be possible. I don't.
I don't know if for judicial efficiency, they may want to appoint someone else who could be here next month or.
Is it necessary to have an appointment?
Yes.
I mean, an additional appointment, so, okay, I will allow her to withdraw. we'll come up with the next person on the list. Is there anybody else here today? Okay, Mr. Haddix will come back to you this coming month.
All right, thank you.
Andrew Murdoch. Andrew Murdoch. Andrew Murdoch. Commonwealth versus is Andrew Murdoch there in Russell County?
I think he's a state, so I don't know if they have like a class.
How about Phelps? Jerry Phelps?
Okay, you too. I'll go get him, Your Honor.
Okay.
It should be on.
Are you ready, Supervisor? What's her name? Ask her about, she's getting. I think he's going to, can be with that. I see what was her.
Y'all are picking up on the record over there. Y'all are picking up on the record. Okay. I don't know whether Russell County has gone after the other people that they are. Are y'all going after Andrew Murdoch or Jerry Phelps?
We don't
Okay,
have
thank
Mr.
you.
Murdoch. Mr. Murdoch got
Okay,
released.
Commonwealth versus Andrew Murdoch, 24 CR 0018. Mr. Murdoch, were you born in 1999?
I got Mr. Phelps, Your Honor.
Mr.
Mr.
Phelps,
Murdoch
okay.
got released.
How do you say your first name, Mr. Phelps?
Jay Ree.
You have to speak up a little bit.
Jay Ree.
Jay Ree?
Yes.
Commonwealth versus Jay Ree Phelps, 24 CR 0027. You're here today for the purpose of arraignment. And you have an attorney or is public advocacy, Office of Public Advocacy is present here. Your attorney, Mr. Pennington. Wave, Mr. Pennington.
Yeah, I'm here.
Okay. The grand jury, right to remain silent. The grand jury of Clinton County has returned an indictment charging you with sexual abuse in the first degree and sodomy in the first degree. You understand those charges? I'm not asking whether you did or not. I'm just asking if you understand charges.
Yes.
Okay.
I understand the
I'm
charge.
signing a reciprocal discovery order here. We need to set a negotiation date on June the 7th. Your next court date's on June the 13th. Your attorney will be able to talk to you. Mr. Stockton, do you have anything else to say about this?
No, Your Honor.
Okay. Your attorney will be over there very soon to talk to you, explain who you are in the process. Is there any discovery over this case?
Judge, we had actually just discussed that. I was kind of looking at what was present. I would anticipate some medical records coming out of state. So I'm just knowing what I know about the case at this point.
That's a different case.
Well, those records, you're requesting, James, with medical records. Well, they'll be a victim. I think she treated in the state of Tennessee, is my understanding.
Oh, okay.
Well, if the Commonwealth doesn't have them, they don't have it.
Right, I just,
Okay, thank you very much. Mr. Murdoch, Andrew Murdoch, next, okay? Andrew Murdoch will be the next case. Mr. Phelps, your attorney will be over to see you.
All right, thank you.
Andrew Murdoch.
Your Honor, we no longer have Mr. Murdoch.
Okay, you know where he went?
I believe he got released. Give me 1 second, I'll check, sir.
I know he's a state inmate out of Pulaski
You
County.
gotta check, see where Mr. Murdoch is. Okay, Russell County. Is there anybody over there that desires some justice dispensed today? If not, we'll
Judge, do you have a birth date on Andrew Murdoch?
1999. Last four digits, 1746.
It appears he is in the Harlan County Detention Center.
Okay. Thank you, Russell County. You may be excused. They took him to
Well,
Harlan
John.
County, evidently.
I know where that is, Judge.
Yeah, you think-
I'm not making it out there live.
Okay, Clinton County. Clinton County Jail.
They moved him yesterday, Judge. I bet he's going there to the SAT pro.
Judge, and he's a co-defendant with Miss Beatty. That was one we just received labs on this week. We could really do anything on it anyway.
Well, let's do a transportation order on him if he's in Harlan.
Yes, Judge.
Clinton County.
Yes, sir, Your
Clinton
Honor.
County, ready? Commonwealth
Yes, sir.
versus James Armstrong. It's generic. Commonwealth versus James, are you James Armstrong?
Yes, sir.
Are you James Armstrong?
Yes, sir.
Is your microphone on? Is anybody there?
Yes, sir. Can you hear us?
Turn it up a little. Okay, Commonwealth versus James Armstrong, 24 CR 00140. And you represent Mr. Armstrong. He's got David.
I was gonna say, I think it's Mr. Cross.
Where is Mr.
Back there.
Entertaining. We have James Armstrong on, Mr. Cross.
Yes.
For pretrial conference, what does the Commonwealth have to say?
Well, there's an additional charge of grand jury today.
Let's step over to the left a
We
little
need to
bit.
get Mr. Cross a few more medical records, and if we can't resolve the case, we'll get a trial date. That's about where we are.
What-
We had one negotiation day.
So is the additional charge related to this case?
It is, it'll be a superseding.
Superseding that, which can be served on, so let's just schedule it for negotiation on June 7th, the next court date on June 13th.
I'll be down, Vince.
Corey Baird. Corey Baird. Commonwealth versus Corey Baird, 24 CR 0028. Are you Corey Baird?
Yes, sir.
Were you born in 1993?
Yes, sir.
Last four digits, social security number 0642. You're here for the purpose of arraignment. Office of Public Advocacy represents you. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with arson in the second degree and being a persistent felony offender along with that charge. Counselor, you acknowledge the identity of your client, received indictment, waive formal reading of arraignment here, plead not guilty, reserve all pretrial motion.
Yes, Your Honor.
Schedule this for a negotiation day on June 7th. Thank you. Next court appearance on June 13th, doing a reciprocal discovery order, so Mr. Baird, they'll have to give you information to help prepare your defense. Your attorney will be down there and talk to you,
And
okay?
Judge, if I may very briefly.
Sure.
It's my understanding that Mr. Baird will be having additional charges today.
Well, I'm unaware of that.
Discuss this with Commonwealth, so I think he is. And we had discussed, once we get those additional charges, sending him for evaluation, so we just wanted to make.
Well, I'll be ready to receive give the order of that, you know, but right now I'm on scheduling
Absolutely.
to proceed. Okay.
Yes, Your Honor.
Unless 2 minutes. Okay.
I'll
Thank
be able to talk to you, Corey.
All right, thank you.
Jimmy Bertram.
On this bit, all right, I'll go get it.
Hey, Jimmy, see you here.
I'm over as Jimmy Bertram. 22 CR 0056. Are you Jimmy Bertram? Were you born in 1979? Need to speak up there.
Yes, sir.
Okay, and the last 4 digits, social security number 1527. Can you turn their volume up? You got it. Okay, forget it.
Just the system volume. Can you adjust the?
That's part of that.
Not to.
Okay, Mr. Bertram, you're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, he has a 5-year sentence on burglary, 3rd degree. He was in special court and was terminated for multiple drug tests.
And we're going to stick to that.
Okay, well, we'll revoke his probation. What's the sentence?
5 years.
5 years and give him credit for time served, okay?
Jimmy, I'll be able to talk to you.
Thank you.
Thank you. Jamie Harrell. Commonwealth versus Jamie Harold, 23 CR 0041. You're Jamie Harold, you were born in 1977. Is that correct, Mr. Harold?
Sure.
Last 4 digits, social security number 3525. Is that correct?
Sure.
Okay. Mr. Stockton?
Your Honor, he has a 3-year sentence on possession of controlled substance, 1st degree. He had multiple positive drug tests and had an absconsion for about 54 days. My understanding is he's going to stipulate.
That's correct.
Mr. Harold stipulates, is that correct, Mr. Harold?
I have one.
Yeah, okay. I'll just revoke the probation, make sure he gets credit for the time he served.
And Judge, I know sometimes this helps if we could reflect in the order of the referral. Mr. Harold would like to get some help for some of his problems. So, you know, sometimes putting that in the order will help him get to the facility with programs as such.
I've seen it in there before. I don't know that it helps, but I've seen it.
Go ahead and put it in order.
Thank you, Judge. Jamie, I'll be able to talk to you.
Robert Myers. Robert Myers.
He's coming, Your Honor. He's here, Your Honor.
Commonwealth versus Robert Myers, 21 CR 0081, 23 CR 0036. Are you Robert Myers, sir?
Your Honor.
You were born in 1967.
Yes, sir.
Last 4 digits, social security number 3705. We're on probation revocation on these 2 charges. What does the Commonwealth have to say?
Your Honor, he has a 5-year sentence. He had 2 possession of controlled substances run consecutively for a total of 5 years. He was granted probation out of this court, and he was at Protea Behavioral Health, and he was discharged because he had alcohol, and evidently they took his keys away, and he allegedly hot-wired his car and went out and returned under the influence of alcohol. And I have is it Mr. Wallaceville? Is that how you pronounce your name?
Yes, sir.
Yeah, he's on from Protea.
Does your client want to stipulate?
Judge, no, I would like to get some testimony from Protea relating to this.
Sir, will you raise your right hand? No, I'm talking about the guy at the rehab.
Yeah, he's got it right.
Okay, I couldn't see your hand because.
I'm sorry.
No, Mr. Myers, you don't need to raise your hand. It's the guy at the rehab. Okay. Okay, you swear the testimony about to see is, gives the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And proceed.
Could you state your name, please?
Gordon Waterspool
And where are you employed?
at Protea Recovery.
And what's your primary duty exactly?
Everything, I mean, I'm the supervisor of peer support, but I was the first person they hired. I've been here since day one.
Okay. Are you familiar or know Mr. Myers?
Yes, sir.
Okay. Did he have a problem with alcohol use at the facility and was he discharged?
Yes, sir.
Did you tell the court what happened?
He had his vehicle on the lot when he got here, and he had left, and we took the keys from him because they're not supposed to have the keys. And then he left again. Well, he came back and didn't pass a drug screen. And then he took his keys and allegedly he hotwired his vehicle. I mean, I think he had another set of keys, but that's what he said he did. And then he came back, left again and came back under the influence again.
Okay. When you say he said that, did he say that he had another set of keys or did he say that he hotwired the car?
He said he hotwired it, but usually we've heard that usually there's another set of keys somewhere, but he said he hotwired it. That's his words.
And so this has happened on more than one occasion with the use of alcohol?
Yes. Those two times.
Okay. And as a result, the first time, that's when his keys were taken.
Well, we should have had the keys anyway. We didn't get them. That's kind of on us. We should have had the keys in the first place, but no, then we took them and then it happened again. The hot wiring.
And then as a result of all this, he was discharged then on April the 11th?
Yes. But that's only a 30 days though, a 30-day. He's eligible to come back after 30 days.
Okay, okay. I don't have anything on this further this week.
Morning, sir.
How you doing?
I just have a few questions, and it's particularly about what you just said. Is Robert, you said Robert is eligible to return after 30 days?
Yes, sir. He can come back on the 11th of this month.
That's something you would recommend?
Absolutely.
Thanks, sir. That's all I have.
I don't have anything else, Your Honor.
Okay, what's the Commonwealth have to say? Gonna come up
Well,
where I can hear you. I'm having a hard time hearing.
I understand they're willing to take him back, but I don't know that that's the appropriate remedy in this case. He,
Unless Mr. Myers decides he doesn't want to use substances and he's not going to quit deceiving people to use substances, I don't know that any rehab's going to.
you know, I like Mr. Myers. I've known him a long time, but he's got this stuff's got to control him instead of him controlling him.
and Judge, I would agree 1,000% that last setting. Mr. Myers has a problem. And what was said last is being recommended and welcomed back. I think give him an opportunity to get a hold of that problem. Jail's not going to help him cure those demons. Going back to Protea and working through a program potentially will.
Well, what bothers me about this case is you've got a person that is under these conditions that we put them on, that goes to rehab and twice leaves driving and comes back under the influence of drugs or alcohol on 2 occasions.
And it's not just his problem, then it becomes society's problem.
Well, that's what I'm saying, you know, I mean, the 2 things that bother me most about people is when we let them out and they get out and drive vehicles under the influence or have weapons. In this situation, on 2 occasions, Mr. Myers decided to leave the rehab, take mind altering substances and come back. So I'm going to say that there's some kind of treatment for Mr. Myers in jail. You say there's not, but I think there on occasion there are, and I'd suggest Department of Corrections put that in order too. Okay. Thank you very much, Daniel Norris.
Say anything here?
Daniel Norris.
God, I didn't do this. I ain't done nothing.
Thank you, sir. You can be excused. Daniel Norris. Are you Daniel Norris?
Talk loud.
Is Daniel Norris here?
It is, Judge.
You got him here for arraignment. Mr. Norris, were you born in 1996? Last 4 digits, social security number 1043. You have a right to remain silent, and your attorney who are present. The grand jury of Clinton County should charge you in burglary in the 3rd degree, criminal mischief in the 2nd degree, theft and lawful taken in 24 CR 0029 and in 22 CR 0030, they charge you with fleeing or evading police in the 2nd degree, motor vehicle, possession of burglary charge, resisting arrest, and possession of marijuana, as well as possession of drug paraphernalia. You understand what those charges are, Mr. Norris? Okay, so you acknowledge the identity of Mr. Norris, you see that formal reading right there, please not guilty or so, not pre-trial motion.
Yes, Your Honor.
I'm signing reciprocal discovery orders. Mr. Commonwealth Attorney, are these two cases out of the same circumstance or different circumstances?
They're related, but they're on different days, and what happened, one arrest led to the other arrest of the break-in at the smoke shop. Basically, they found.
So they couldn't be tried the same.
Well, Judge, and there's a third.
There's two more came.
One or two more coming.
Yeah, so.
Okay, you want to schedule it in June, or is that too soon?
We can schedule in June, because we'll put that stuff on docket sheriff and Mr. Penny.
Okay, well, let's head and come back on June the 7th at 9 a.m. for negotiation and June 13th. And if you don't have the indictments ready by then, I guess we can do it by information.
They should be returned today.
I think they're gonna be returned today.
Seem to know a lot about what's going on in the grand jury.
I think I might need to put him on as assistant.
Well-oiled machine, Judge.
Yeah, I know. Okay, your attorney will be over to talk to you, Mr. Austin. Michael Taylor. Michael Taylor.
We're getting him, Your Honor. Good news, Your Honor.
Okay, Commonwealth versus Michael Taylor, 24 CR 0002. You're Michael Taylor. Mr. Taylor was born in 1984. The last 4 digits of social security number are 2856. Is that correct, Mr. Taylor?
Yes, Your Honor.
Yeah, okay. It says a competency hearing. What do you have here?
Well, Mr. Cross wants a hearing, and I think, contacted KCTC, our office did, and Dr. Sparks is available May the 23rd from 11 to 1 and June the 13th, 11 to 1 on those 2 rule days.
Your Honor, when we,
Are those Cumberland County?
One's May 23rd in Cumberland, the next one's Clinton on the 13th.
when we first, Your Honor, in court,
You need to speak up a little bit so you can hear you.
when we discussed Mr. Taylor being examined, the question was, will he be taken to KCPC or will it be done remotely? At that point in time, as I recall the discussion, if it was done remotely and we had concerns, we would be able to move for him to be taken to KCPC for an in-person on-site exam. I've got a lot of medicals on Mr. Taylor. I spoke to the examiner 2 or 3 days before apparently he remotely on Zoom interviewed Mr. Taylor. And you don't really appreciate Mr. Taylor's problems unless you talk to him in person. But we talked about medicals that he needed, and the next thing I know is I'm getting a report that says he's basically competent and such. And we're going to have at some point in time, unless, well, we'll have to have a hearing at some point in time. It's going to take some proof from his VA doctors, but I believe Mr. Taylor's case merits an in-depth, full KCPC exam.
If you want to enter an order for him to be mandated to go up there, you can try, but it's going to be a year away.
Well, I had understood that under this set of circumstances, it would and could be expedited, and I'll do whatever I can to help expedite it. I know the court
I just
would.
don't know that they'll expedite it.
Yeah, well, I understand, but it's a situation where it deserves a, Mr. Pennington, have you had any experience lately with that? No?
Not only with the outpatient, those are still about 3 or 4 months turnaround.
But this one is, in my opinion,
Well, this
based.
examination has been on behalf of the Commonwealth.
That's correct. You can always hire
You
him.
can hire
Yes.
someone to evaluate if you want to.
Well, I think we're going to have an opportunity to do that or get the
Well, you do
VA.
have an opportunity to do that.
Well, it's going to take some time. We'll do that.
Well, you want to reset it for a status conference so then I can find out when was that the hearing?
I think that's what we need to do, and then let me get with his family and see what they.
May the 2nd is today, and I'll give you, it's a little longer out to the next one, so I'll give you to June 13th. That gives you a little longer.
Fine, Your Honor.
June 13th for status.
I'll be down, Michael. Thank you.
He's gonna come see you. Now, we have one other case down there, it appears to me. Dennis Kempton. Dennis Kempton.
You go over experience, huh?
Yeah, Commonwealth versus Dennis Kempton. 23 CR 0060, is that correct? You can check that. Under 60.
It is 60, Judge. 23 CR.
We're here today for the purpose of sentencing Mr. Kempton. What is your year of birth?
12 months of
What is your year of birth, Mr. Kempton?
1974, sorry.
Okay, and the last 4 digits, social security number is 8161.
Yes, Your Honor.
You're here today for the purpose of sentencing. Have you seen the pre-sentence investigation for the probation and parole? Have you seen that, gone over the probation, pre-sentence investigation board? Did your attorney go over the papers with you?
Yes, Your Honor.
Okay. Counsel, are they substantially correct?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty to burglary 3rd degree, he shall receive a sentence of 5 years probated, 5 years supervised. He should pay restitution in the amount of $310 at a rate of $100 per month plus a 5% clerk's fee. First payment will be within 30 days from being released from incarceration. Restitution will be paid from the circuit clerk's office. Court cost on an amount of $155, and he'll pay that at $30 a month. First payment will be in around 30 days from today. So it's $130 a month, 100 toward restitution, 30 toward court costs. He shall receive credit for time served, and is this needs to be supervised. So when does he get out? When can you see him?
He can be released today. I'll be down to the jail.
When can you see him?
I will see him on 5/27 at 10 a.m. Central. Or 5/7, next Tuesday.
Next what?
Next Tuesday.
Or will they be released next Tuesday? So what time you want him to be over there?
He needs to be at the office at 10 Central.
Okay, I'm gonna let you out at like 8 o'clock Central Time next Tuesday, okay? So you have somebody there ready to take you over probation, parole, and get you set up, all right? Okay, thank you very much. Now, is there any other matter to come before this august court?
They come and pay all the restitution and all that, and then they give the remaining balance of $17,000 fine.
I have no objection.
Okay, submit me an order. Okay, that concludes the business of the Clinton Circuit Court.
Thank you, Your Honor.
Thank you very much.
Well, something got wonky with the judge violence.
You gonna turn this off the record?
Maybe down in district court. And this is the
Yeah.
eligibility.
Yes. Yes. Amy first, and Robert. I quite look at paperwork before I can manage. Okay, when do you have to pay for it? I'm gonna take, well, Jimmy and Robert. I don't know. No, I'm gonna take that with, I'm gonna take Jamie and Robert both. To Russell County. Okay, I will text you. Okay. Oh, he said that Jimmy and Robert, Jamie is all. They won't get it. I may take Jimmy and Robert, they want to Wayne County. I'm gonna take, I want to take two of the Russell County. One. What is it? A probation officer. Carmen, the Carson, see, Carson. Hello? Yeah. Just who? Okay, yes. It would be like from 3 to 11 some and 11 to 7. Let me check and see. Give me your number. Hold on one second, please. Go ahead. 306 2558. Okay, on a Saturday on the 2nd, he says he's working on the 2nd and 3rd, Friday and Saturday, or Saturday and Sunday. Saturday and Sunday. Okay, let me check and see what I got, okay, open up now. All right, bye. County Jail. Ms. Bruce.
Start my video. Okay. Okay, case of Cabinet versus Jameson Cooper.
Yes, in this case, Your Honor, non-custodial parents ordered to pay $450 a month on current, 25 on arrears, and asking that $600 be paid by May 31st.
Okay. Cabinet versus Joseph Cook.
Judge, in this case, asking the non-custodial parent pay $493 per month and 99 on arrears beginning on May 1st. Oh, this is a motion to establish. Yeah, this is a motion to establish paternity, so might want to put Stephanie on that hold real quick.
Raise your hand. You swear the testimony you got to give us the truth, whole truth, nothing but the truth. You need to speak up there, okay?
State your name. If she wants to. Cheyenne. Mother's here, Judge.
Are you Joseph? Okay. He's here.
Okay.
Sorry.
Struggling, Judge. State your name.
Stephanie Witham,
By whom are you
You
employed?
want to come over here, man?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar with the case we're hearing today involving Joseph Coe?
Yes,
Are you the caseworker in this case?
yes,
Okay, and was there DNA done in this case?
yes.
Okay, and what were the results of the DNA test?
Mr. Cope was found to be the father at 99%.
Okay, and did you do a figure on what child support amount should be?
Yes.
And what did that figure come out to be?
$493 per month.
Okay, and was that based on the Kentucky child support guidelines?
Yes.
I think that's it.
Okay, Ms. Perigin, you have any questions you'd like to ask? Mr. Copeland, you have any question? Not necessarily. You can go into circuit court and file for visitation. This is just child support here. Okay, but it doesn't mean that you won't, but now that paternity is established, you probably need to see a lawyer and see what you can do if you want visitation, okay? Okay. You can get a copy of the orders, next door here, next there. Lower versus lower, or Lauer versus Lauer, which one is it? Lauer versus Lauer. Okay, what do you have?
So just as a motion to decrease, and I'll probably just let the staff, just needs to testify on this, maybe give a little testimony on this one.
Okay.
State your name.
Stephanie Witham,
What's your position?
caseworker.
Are you familiar with the case here involving Ashley Lauer versus Jonathan?
Yes,
Okay, and was a motion to decrease filed in this case?
yes.
And what was the basis for that?
The respondent filed for a review,
Okay, and what were the results of the review?
decreased to $511 per month.
Okay,
From what?
$782.
Okay, and what was the basis of that?
I think his job has changed since the beginning, since 2022 when we said it.
and is this figure based upon the Kentucky Child Support
Well,
Guidelines?
what kind of proof do you have?
He provided proof of his last job at Talent Drilling. He's not.
Where's that?
This is his wages from Talent Drilling.
And where is he employed at now?
Right now, I'm Nathan Thrasher, they ain't got no permits to do no drilling, so I'm helping them right now.
Right. So,
I don't know, it seems to me like there's some dissent while I'm here. You think you need to take some proof?
Yeah, or might even wanna, I can take some proof from her, or maybe review this again, set the motion for next month and do a little bit more digging into
I
this.
think you need to do some digging and you need to
Digging.
take some testimony under oath. Okay?
Yep.
Okay, thank you. Manis versus Manis.
See what this one, Joe, which one is that one? Okay, yeah, we got it. Okay, Judge, in this case, the non-custodial parents ordered to pay $217 a month on current, 50 on arrears. We're asking that 500 be paid on or before June the 12th.
Great. Cabinet versus Muse.
Judge, we have an agreed order in that case.
Gormley versus Pierce.
Judge, we have an agreed order in that case.
Cabinet versus Rivera. Kelvin Rivera.
We have an agreed order in
Kelvin
that
Rivera
case.
here. Have an agreed order.
Yeah, Kathy got an agreed order.
This is Kevin Rodriguez signed it.
Did I give you the wrong one?
Which one is it? It says Kelvin Rivera as a respondent. It says have seen and agreed to Kevin Rodriguez.
I believe it's Kelvin Rodriguez Rivera.
Okay. Is it?
That's Rivera on the system.
That's your middle name, Rodriguez. Last name's Rivera.
You need to sign it. Rivera on the end of it there.
Oh, yeah, put Rivera there. Awesome. Yeah, he did it.
Y'all can work today because it's. Okay, Cabinet versus Roberts.
Agreed order, Judge. It says it written.
Wilson, Cabinet versus Wilson.
It's this Norris McDaniel versus Barry Wilson. We got 3 Wilsons in this.
That's very.
Barry. Yeah, this is an arrears out of state case, asking pay 700 by June the 12th.
Cabinet versus Wilson.
Yep, I think this one is
Dale Wilson.
Yes, have an agreed order, Judge.
Cabinet versus Jelena Wilson.
Yes, Judge. Have an agreed order in that one.
If that concludes your document.
That does, Your Honor.
Thank you all very much.
Thanks, Judge.
Criminal docket. Afternoon criminal docket. Commonwealth versus Cody Smith.
He is, that's fine. He is. That's where I'm assuming he's at. That's where I saw him at. That's been a week ago since I've seen him.
Hey, Dennis, this is Carson. We need Cody Smith on Zoom. Sorry. Thanks, sir.
He didn't
Working
have,
on it. Yeah.
he didn't have a bond, so I'd say it's. He didn't have a bond, so I'd say he's still doing it.
Where's he? Yeah. I just did, ma'am.
Is he here at jail?
Yes.
Go down and get him and bring him up here. Yeah. We'll just pass over this till we get him up here. Okay, we ready for the civil docket? What is this? Yeah, Commonwealth versus Kaylee Swift. What's the Commonwealth have to say? Are you Miss Swift?
Yes.
This is 24 CI 0017. Y'all move to the left just a little bit. What?
Pre-trial diversion agreement.
Okay. Ms. Swift, what is your, let her be in the middle there so she can get behind the microphone. You get to the left there. Where's my stuff? No, I'm talking about the cheat sheet. What's your year of birth, ma'am?
2001,
And the last four digits of your social security number?
257.
A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
You just plea freely and voluntarily given.
Yes.
Are you the same person that we just identified when you indicted?
Yes.
Is your judgment impaired today in any way?
No.
Where's your file? 24 CR 0017. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you?
Yes.
You believe that you fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. Before I can accept a plea guilty, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor, a right to bill this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea, you don't give up those rights. You say that. Now, I may consider the Commonwealth's recommendation about making applying range of sentence allowable. I don't have to accept the recommendation. However, in the event I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea to proceed to trial. And I understand there's going to be an offer of pretrial reversion. So what I'm going to do is go over and see if you're qualified for the offer to you. Okay? Have you previously been diverted in the last 5 years?
No,
Any felonies in the past 10 years?
no,
Are you currently on probation?
no,
You understand that if you fully complete the diversion agreement, the charge will be dismissed and you can have your, this expunged from your record. You understand that?
yes,
You understand that if you do not successfully complete the diversion program, you brought back in front of the court and your diversion was voided, I'll order a pre-sentence investigation report. You, in the sentence, you'll be a convicted felon and that can be used against you in future felonies. You understand that?
yes.
Who's bringing forth the Commonwealth's recommendation?
I'll read it wrong.
No, they'll, and that's it.
Your Honor, Ms. Swift will plead guilty to unlawful imprisonment, first degree, receive a sentence of 2 years, 15 days in jail, serve 15, and after she serves that 15 days in jail, she can serve 15 days home incarceration with the balance pretrial diverted for 2 years supervised. That she will have no contact with the victim during the pendency of her probation. She'll receive credit for time served, but my understanding is she'll still go into custody and she will obtain and maintain gainful employment.
Is that what you agreed to?
Yes,
Are you pleading guilty because you committed the acts charges in the indictment as amended?
yes,
Plead guilty of your own free will because you are guilty for no other reason. Nor your constitutional rights are explained to you, still your desire to proceed without a court to set punishment at the end of this plea, correct? Okay, is that your signature?
yes,
Except for again. And she got 15 days to serve, is that right?
That's correct, Your Honor. Mr. Willis was a co-defendant. He got 30 days to serve, but she was pregnant, so I cut it down to 15. There was an assault and unlawful imprisonment, conspiracy.
Hey, when are you gonna be, you'll go down and see her in a week or so?
I'm gonna, yeah. I'll go see her and tell her when to.
Well, you need to take her down here. But when you take her down here, you need to tell the jailer that she needs to be transported. They don't keep women prisoners here, so you don't be kept here. You'll be in Russell County where it's a little nicer. Not that they don't try here, they just don't have the facility to take care of them.
Yeah.
So they'll transport you, okay?
okay.
Okay. Thank you very much. Let's go off the record so you get back here. Commonwealth versus Cody Smith. We sit down. Clinton County Corrections had Mr. Smith up here so he can participate. Mr. Smith, earlier, I had people on Zoom. I wasn't sure that they would completely hear and everything, so I want you to be up here. What do we have here today? It's got a motion for bill of particulars, is that correct?
Yeah, motion to vote on.
Well, let's do the motion for bill of particulars first. What we got?
Well, I just see that this way you keep Mr. Wittenberg.
Well, wait a second. Y'all move over here and let him behind.
It relates to honor revocation, he doesn't relate to criminal.
Okay.
Basically, he was wanting information regarding the stick that was used to test Mr. Smith at the last court meeting.
Okay.
According to Mr. Payne, I could do it in writing or I can have him testify. They don't track those, but I'm what a lot they come out there. So.
Well, what, you have a motion you want to make then about the entire process and stuff here?
Yes, Your Honor. As Mr. Stockton said, this is a motion over a drug test that occurred the last time my client was in court. And what I was wanting to do was ask some questions and verify that this was an accurate and valid test. Because I don't think that stuff was checked. He had, I'm not sure what counsel he had, but the court appointed him some type of counsel because I wasn't able to be here and I didn't properly give the court notice that I wouldn't be here. But
Well, let's start there. You can't just give the court notice that you're not going to be here. For the last 2 or 3 times, you sent a notice over here that you can't make it. That's not good enough. You need to call a Commonwealth Attorney's office and make arrangements for an alternate date. If he agrees, if not, we need to get somebody to stand in. If we let people just summarily send a notice over here that they're not going to be here, we'd never conduct any business. So I don't accept that as a premise that we're stating something.
Your Honor, respectfully, I have done that. And respectfully, Your Honor, back on February 29th, I was in court here on another case. I informed the court on that date that I had a trial scheduled for a Thursday and Friday that would more likely than not go. And you told me on that date, it's on video, that you only have one motion day a month.
And to get somebody
And to go ahead and do that, just have somebody coming down the calendar or something. And I had to do the same thing on that one because I was in trial. The same thing on his, as soon as I found out that I was going to have the trial, I sent notice to the court. I'm not sure if I contacted Mr. Stockton or not, but I sent
The
notice.
office contacted me. I can't remember the lady's name that I dealt with. We had difficulty trying to arrange a date for something Mr. Wittenberg wasn't available.
Okay, you go ahead and proceed.
Well, I've done my due diligence in trying to make sure and have everyone informed, Your Honor. I've informed the court, I've informed Mr. Stockton. The last time he was here, he was appointed counsel. I'm not sure what counsel he was appointed and stuff. But it's my feelings that that counsel, to the best of my knowledge, he didn't have the case file or anything. And he was given a very little time to prepare for whatever.
Wasn't
hearing.
anything done on the case. He came in here under the influence is what happened.
He was late.
He was late, he wasn't here on time, and then he came in under the influence. So it was direct contempt.
That would probably be on me, Your Honor.
And then I called the public advocate up and asked him to stand in to see if he wanted to talk to him. I believe it was Mr. Penny.
Yeah.
Is that correct? That's correct. Would you go ahead?
Your Honor, that would be my fault. I'll accept responsibility for that. I contacted my client. I told him, I said, I'm in a trial that starts Tuesday. I said, more likely not, it'll go
He
Friday.
did all right with the late. He came,
Well-
they got in contact. I was okay with the late because it could have been a miscommunication. But it's not your responsibility that he came up here under the influence. He was obviously under the influence, so I had him to test him.
Well,
And what did, I want you to raise your right.
if I can finish, Your Honor, before we do that.
Sure, absolutely.
I told him not to be here because I told him I would not be here as his counsel, his privately trained counsel to represent him. And, I told him not to come, is why he didn't come that morning.
Well, was he told previous that at 8 a.m. that day, he was told, did he call in? What happened? He called in to ask if he had to be here to that day, and he was told to be here. Were you aware of that?
No, I was not, Your
Well,
Honor.
no, you weren't, because you would have told me if you'd been aware of it, so I'm not saying you were, but he called in here, asked if he had to be here today. Was told he had to be here that day. Then he didn't show up, came in late. When he came in, he was under the influence. Now, I can't let people come in here under the influence and not test them for their own safety. If people come into this court and they've got all kinds of drug cocktail in them or something like that, I let them go out the door and they get in a car and run over somebody, or they die themselves, and we have responsibility. Now, I don't know this gentleman, and I don't have anything against him, but he was under a bond not to be taking any of these illegal substances, anything. So not only was he in violation of his bond in situation, but he was under the influence. That's what got him put in jail. Okay, now if you won't take testimony from this officer, very good. Raise your right hand. I swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
You may inquire.
Can you state your full name for the record?
Carson Payne, probation and parole officer for District 20 Monticello office, supervise Clinton County probation and parolees.
Okay, how long have you held that position?
I have been with the Department of Corrections right at 11 years. However, I've done different positions. I've been back since December of this year as an officer.
Now, I think the date is February 11th. I may be mistaken, but February 11th, I think is the date that you were here and you drug tested Mr. Schmidt. Do you know if that's?
I think it was the last court day. It was April 11th. April 11th.
I may be, yeah, it may be April. I may be mistaken on the date.
Yes, April 11th.
But you tested him from the
Yes, sir.
court and stuff like that. The court requested you test him?
Yes, sir.
What type of training do you do when you do your testing, like to do your job? Do you go through certain training, annual or what?
We have yearly in service. When I was hired 11 years ago, I was trained on drug tests. They basically took me in the room when they drug tested somebody and I watched them and they told me how to do it, and that's how we've done it.
But do you get recertified every year or do you take?
We do
updated
not
classes?
have drug test certification.
Okay. On the date that you gave Mr. Smith the test, can you go through exactly what you did, what the procedure is when you give a test like that, step by
Well,
step?
I was sitting there and judge asked me, told me to get a test ready. And I said, I've got one right here in my bag. When he come back in, he said, test him. And I walked over here and I reached down in my bag and drawed a random cup out. I got 3 or 4 left in there. Drawed one out, walked back there, tore the lid off, handed it to him. First, I asked him if he was gonna be dirty. He said he was gonna be clean. I handed it to him. It took him a few minutes. He provided a sample. I put the lid back on it. I'm just gonna waste this test to show you. After pull it out of this bag.
You're blocking the camera off.
Yeah.
On camera there. Okay. Thank you.
After he, yeah, right there. My bad. After he filled it up. I'm thinking, which I do 100 drug tests a month. He had a pretty good amount in it. I reached over here. Actually, I probably pulled my pocket knife out and peeled this back. Peeled it back. I read it. I told him to come with me. I walked straight up to the bench and I told Judge that he was positive for oxy, meth, and Suboxone. Held it like this, and the judge said, thank you. And I walked back in there and poured it out, and that was it.
Would you give a test like that? Is there any paperwork associated with that, any forms you fill out or anything?
If you're on probation, if you're on my caseload and you come into my office, I'm gonna come in, I'm gonna drug test you. If you are negative, put the lid on it, pour it out, throw it in the sink, walk out, and I enter it in the computer. If you're positive but will not emit, I fill out a lab form, we send it to the lab, then when it comes back from the lab, we do it. With this being in court, he was not on my caseload. I tested it and I threw it away and I never thought a thing about it. I had to go back and listen to the court record to see what it was positive for because I don't take notes on it. If Judge asks me to do it, I do it and I walk in and say, Judge, this is what it is, and I forget about it because it don't have nothing, I don't have any follow-up to do with it.
So I can assume that's a no, you didn't do any paperwork associated.
I've none.
So as you sit here today, can you tell me, I guess, what can I look at the paper on that? Where I reference it correct, the plastic cover of the, drug test. Everything, the other cover.
The one I peeled off?
Yes. My approach with Sean, no, the plastic one and stuff.
The bag.
And all that, yeah. Before you administer this test, I guess, did you, confirm the catalog number or the line number or the expiration date of the test?
I did
you do
not.
that?
However, when I left my office that morning, I put a new test in my bag and we rotate them in our office to make sure we use the oldest first. And I don't look at that because we get drug tests in, we get 1,000 per box and we go through 500 a month plus at our office. So they stay in date. That's not something we have to worry about because this one right here is not out of date until 2025 and we're in 2024. This one's got over a year from today. So these tests will be gone by then.
So, I guess a yes or no to clarify. Yes or no, you did or you did not check the expiration date of that test?
I did not physically check it before I tested it.
So as you sit here today, you can't positively say that it was in date. You're just making an assumption.
Yes, however, the other test that's in this bag was in here that day and they're in date. So I assume it was, but I cannot positively say it was.
And I think you said the specimen was not lab?
It was not lab.
Okay.
We cannot lab test. The only tests that the state will allow us to lab are ones that are from our office because probation and parole has to pay for them tests. And where the judge was asked me to do it. Now, if the judge looked at me and said, I want that lab, I could have done it and probably got away with it. Probably got my hand smacked, but Judge Williams asked, I'm going to do it. But if he does not ask, I'll say, okay. And I walk back there and I dumped it in the toilet and threw the cup away.
But usually, I guess it's on your caseload or I think that's what you said, or.
If they're on my caseload, the only way I lab it is if they don't admit or I have a reason to lab it. We only lab probably a 10th of the tests we do because most people, once you test them, they will admit to use or they're negative. So.
And in this case, Mr. Smith denied having anything in his system. He said that, I guess, said he'd be clean or good. I'm not sure what your word was.
He denied it, but the judge didn't ask me. I told the judge what it was and he took him into custody, so I threw it away.
Were you ever asked by Mr. Smith's attorney about the test results or anything?
I don't recall him asking. All I recall is walking out here, and I think I even walked up to the bench to show the judge the cup, and I said it, and I turned around and walked back. I don't recall him asking me any questions.
Did Mr. Smith's attorney confirm the results of the test? Do you recall if you showed it to him or not?
I don't recall that.
Did Mr. Smith's attorney ask for the specimen to be labbed or anything?
He did not.
Do you have a specific amount of time, I guess, when do you just swish the contents? What do you do when you?
Your Honor, I don't guess it's like getting territorial when I ask that.
No, that's not, Your Honor. How long did you wait before you tested that or read the results?
When you pull this back, the urine will go up the thing, and once it goes up, you'll get lines. And once it is lit up, you can tell, and it was ready to read because the top line, it'll have all of them have a top line. If it's negative, they only have one line. If it's positive, they have two lines. If it's negative, I'm getting that backwards. If it's negative, they have two lines. If it's positive, they have one line. And all the substances except these had two lines. So it was ready to read.
So in your training, you're not told to wait a certain amount of minutes or anything, just when the lines are filled up or is that what's done?
And if it's slow coming in, sometimes you can start to see a line and it'll take just a second, but his that day did not have any lines. And I'm also thinking I think the judge was dealing with the case when I come out of the bathroom, so I waited a couple minutes before I showed it to him. So.
Thank you, Carson. I have no other further questions.
And you got anybody else you'd like to call?
No, Your Honor.
Okay.
I would make the argument.
Go ahead, make your argument.
Your Honor, as we stand here today, Mr. Smith came to court, and I guess the court observes what they deem to be him being under the influence. Mr. Smith was appointed an attorney that, and through no fault of his own, I don't know, didn't inquire about the drug test that was taken. He didn't inquire about whether the date was expired. He didn't check, normal things that should be checked by a competent attorney to make sure that a drug test is valid. The testimony revealed that he doesn't know exactly what the date is, that he's assuming that it was a test that was in date. He doesn't say that Mr. Smith or his attorney asked for the specimen to be labbed. Our argument would be, Your Honor, that this is an unreliable test. Mr. Smith didn't have adequate assistance of counsel. In fact, I'd call it ineffective that he was here, and we request that he do another test today, and that way he's got his attorney here today where I can check the expiration date, the lot number, and I can see that everything's done correctly, because I just don't think it was done that way the first time. And if it's all correct, then there'll be no objections from me from it. But I object to this test because it's not been verified that it was a test that was valid.
There's several things wrong with this case. Number one, I don't think Mr. Wittenberg should ever have told him not to appear in court, because in the interim, while Mr. Wittenberg had a conflict of being here, Mr. Smith had already been charged with a felony, which is the basis of my bond revocation. He came in here, he was late, and it was apparent, I think I was the one that asked the court to test him because he was in such bad shape, he barely could function. He was tested and he was taken into custody. None of his rights were violated. There was a proper test. The only thing Mr. Smith had done, he appeared to have committed the felony. He didn't appear in court on time, and he's high when he got here. Other than that, he was probably doing okay.
Your Honor, a very short rebuttal, just so I can clarify, because I don't want to be in conflict with the court and not doing what the court's ordered and stuff. But if I can't be here and I tell my client that I'm not going to be able to be here, that he has a right to counsel as we go forth in the future, should I tell him to come to court without counsel?
Well, you're the only person I have this problem with. So I really haven't thought about that. Everybody else appears with their client, and if they can't be here, they have someone else to be here in their presence. So I don't really know the action, but I will tell you this, you do not have the authority to tell your client not to be here. And if your client had come here, walked in the door, had not been stumbling around and not been under the influence, he probably would have been able to go out here. Was there a warrant out for him?
No.
He was under a bond
He
condition.
was under a bond condition, and I filed a motion to revoke his bond, but I wasn't going to have a hearing because Mr. Wittenberg couldn't be here.
And why were you going to revoke it for?
Well, I've got my witness at it. He's charged with assault, domestic violence, wanton endangerment in the underlying case.
Yeah.
There's a new felony one out of him for assault, domestic violence with another lady. So that's the reason I filed the motion to revoke the bond.
So he's going to be arraigned on that, or what?
No, I had to
The
get
bond revocation.
special prosecutor to do this.
Okay.
John, unfortunately, I'm a sole practitioner, and I try to accommodate the court. I've even at one time went to Cumberland County for a negotiation conference on Mr. Smith's case, and appeared at 1 o'clock I was supposed to, and the Commonwealth wasn't there. I've never gotten any official explanation. I never got a call to the office or anything like that. But I appeared like I was supposed to. I've always tried to accommodate the court and do it, but unfortunately I am a solo practitioner, and I can't always be here if I've got trials set from other courts, and they're usually trials that are set well in advance, but
We're losing focus here. This case is not about Mr. Wittenberg. It's about Mr. Smith's conduct. Mr. Smith's the one that showed up high here. He's the one that's indicted for assault. He's the one that committed another assault while he's on bond. It's not about Mr. Wittenberg.
well, Your Honor, we're here on a drug test. I've made my concerns known to the court that I think it's valid.
Here's the thing about it. There are 2 or 3 things that make this happen. Number one, the Commonwealth observed his exit. I had already observed it. when he calls attention to this gentleman, I look at him. The Commonwealth, it's not enough that they come up here and want somebody drug. I have to observe myself. And I did observe. The guy was not functioning. Okay. So I asked probation and parole to do a test. And you might want to challenge that test, but there are thousands of these tests relied upon all the time, not as for the quantity, but just the presence of these things. Okay. And all the time, there are decisions made on the presence of these multiple drugs that he had presence here. So you can take it up if you want to. That's your prerogative. But I was a sole practitioner. If you cannot be here, when you do your schedules, if you're going to practice in Clinton Circuit Court, you should not schedule things on the one day a month that we're here. If somebody tries to schedule something that you got here, you're going to say, I can't be there that day. That's Clinton Circuit Court Day. Or you get somebody else to be here. There are a lot of lawyers that for $100 or come here and make sure you're protected and whatever. So, but as Mr. Stockton said, that's not the issue. The issue is he had a bond revocation here, which we're going to have now. Okay.
I'm ready.
Okay, you ready?
I call Haley Harper as a witness.
Okay.
Since this is domestic violence case, I'd ask them to say that I won't have this.
Yeah, y'all clear, y'all clear. Okay, have her sit right again. Okay, Mr. Stockton, will you state your case for bond revocation?
Yes, Mr. Smith is under bond.
Get behind the podium, get behind the podium.
On 23 CR 67. While out on bond during this time, he was cohabitating with Miss Harbor and committed the acts probably of unlawful imprisonment and assault. And that's what she's here to testify about.
You raise your right hand, please. Swear the testimony about gives the truth, whole truth, and nothing but the truth. Proceed.
Miss Harbor, at one point in time, did you and Mr. Smith live together? You'll have to speak up.
Yes,
And where do you live?
755.
You're gonna have to speak up, lean toward the microphone and speak.
755 Liberty Lane.
Okay. And how long did you live there with him?
Probably from
And
December.
you gotta speak up, like you're yelling for somebody outside, yell, okay?
Maybe like December to last month, so like,
Okay. After he allegedly hit you and kept you at the residence, did you leave? Have you been back?
yes.
You have, okay. You remember taking out a warrant on Mr. Smith?
Well, I ran to the neighbor's house. and they
Okay,
called-
just tell us what happened that day. Have you been threatened or bribed and don't want to tell your story today?
No,
Okay. Well, you went to the county attorney's office, didn't you?
I just,
You told your story down there, didn't you? I can read it to you if you want me to.
Read your statement.
Says the fine Haley Harbor states that during April the 3rd, 2024 through April the 4th, 2024, the above named defendant unlawfully committed the offense of assault in the second degree, a class C felony when the defendant intentionally caused physical injury to another person by means of a deadly weapon or dangerous instrument. The fine.
Your Honor,
Yes.
that's her statement, or she said assault, third degrees, that's her statement, or is that?
Well, that's the warrant.
That doesn't seem
Read
like
your
that's her
statement, you got a
statement.
copy of her statement.
I thought that was it. I'll just ask if you can, bring me the district court file, please. I thought I had all this,
Okay,
just the
young
complaint.
lady, here's the deal. I know this is uncomfortable. You've signed a statement. You need to tell the Commonwealth what happened there that day. And you need to do it in an audible voice, okay? Ask her again.
Okay. Evidently, this happened on April the 3rd, 2024 to April the 4th. Is that correct?
Yes.
Now tell us what happened.
He just flipped out.
He flipped out. Okay, when he flipped out, did he strike you or hit you? He did?
Yes.
In what way?
Your Honor, he's leaving. I would ask.
That's all right. Overrule your objection and let this young lady testify as to what happened. It's difficult on her, which you ought to recognize. Thank you.
I do, Your Honor.
Proceed, Mr. Stock.
In what way did he strike or hit you, Miss Harper?
Just hitting me.
He hit you with his fist?
Yes.
Okay, you also said in your complaint he kicked you, is that right?
Yes.
And he hit you with a belt and belt buckle? Is that a yes?
Yes.
Okay.
Again, Your Honor, I would just want to preserve for the record that I'm objecting to the
Overruled.
Okay. Now, you also allege that he wouldn't let you leave the residence, is that correct?
Yes.
Okay. In fact, when you left the residence, you had to go to a neighbor's house, didn't you?
Yes.
And you saw Connor Duval, works for the Tennessee Highway Patrol. He's the one you first saw. Is that not correct?
Yeah, the door was just open, so.
Okay. And you told Mr. Duval what happened, didn't you?
Yes.
Okay. And after you saw them, ultimately you went up at Michael Rames's office and signed a complaint as to what Mr. Smith did to you. Is that correct?
Yes.
Okay. I have no further questions.
You may inquire.
Prior to the April 3rd and 4th incident, how long did you all live together or, known each, I guess lived together? How long did y'all live together? Did y'all live together?
Since this, December of 2023.
Since December 2023? Prior to this incident on the 3rd and 4th, had he ever done anything like that to you prior to that?
No.
I guess April 2nd, 3rd, 4th, had you consumed any drugs, narcotics, or anything like that?
No.
If you know, is there a reason why he, I think you said flipped out?
You just, I think we both had a lot going on.
I'm sorry, I can't hear you.
We both had just a lot going on as far as, problem, just in court over our kids and stuff. And he was under distress.
Okay. Did you hit him first or, what exactly happened then? I mean, was there an exchange? Was it a fight or was it just him or what?
I'm not sure what made him do that. He's never done that. I don't know.
No further questions, Joe.
No regret.
Okay. Will this witness be excused?
Yes, sir.
May be excused. You have any other witnesses?
I have no other witness.
Okay, you have anybody you'd like to talk?
No, you're okay.
You'd like to make your case?
I would, Your Honor. I would like for the court to take note of the fact that Mr. Smith is charged in the original case with assault, wanton endangerment, and intimidating the witness in the legal process. And I'm pretty confident to say, I don't know if anything's like that's happened in this case, but I've got him on.
Just for the record, let's recite what the underlying facts in the case. Please.
In the underlying case, he allegedly attempted to run over his current wife, which was witnessed by a neighbor who threatened her. And I've got him on audio tape where he's screaming at the top of his lungs, telling him he's going to murder her. And that's on audio tape. So I feel very comfortable saying that in front of the court. In this case, you heard what Ms. Harper said. He struck her with a belt. He hit her with a fist, kicked her, and he kept her there 2 days. So he's dangerous to himself and to others. And I'm asking to be held out without bond, and we'll set this case for trial.
You can come up and make your argument.
You already heard the testimony that she said he had never done this before. I think that they'd lived together since December of 2023. She wasn't able to testify where it was a mutual altercation as far as who struck who first. I don't think, other than this allegation, if there's been any other allegations against him as far as doing anything improper after he was put on bond in the first case. I would agree this is not good if this has happened. I'm not saying it is. But I don't think he's a danger to anybody. He has very little criminal record that I'm aware of. I think he's got a few things, some traffic stuff, and I think maybe a possession charge, but nothing major, nothing violent that I saw in my records. I don't think he's a danger. I don't think he should be revoked. I mean, if the court wants to do some type of restrictions, such as a house arrest or something, I feel like that'd be more appropriate. And just as Mr. Stockton said, I do think we need to set the original first case on for a trial date and get it tried as quickly as possible.
Mr. Stockton, there was that from the district court file, if you'd like to attach that to her testimony.
That's what I was reading from and the complaint with her signature on it.
That's what should, I'll admit that to the record, just exhibit. If you want to bring it back up here.
Yes.
Put it in exhibit. Okay, well, you know, the fact that someone that this, I'm kind of incredulous at the argument that this frail little girl here would be that testified, this young lady would be a threat to your client in a fair fight. I don't know whether he should be afraid of her, or have to kick her or beat her or hit her with a belt or that sort of thing if they got in some kind of altercation. I will just tell you, obviously she was intimidated here, and the president looked like to me. And when she did her statement, she says that he denied her leaving the residence for the 2 days. That during the past 2 days, he has beaten her with a belt buckle, stomped on her with boots. She went to the home of a neighbor, tried to escape, and it goes on down through there about all the things he did. Now, I know it's an allegation. It's a sworn statement. But then you have the situation on top of that, that he's already out on a violent charge where he did this to another woman. And he's been indicted by a grand jury on that. We let him out on bond. He comes up here under the influence with drugs in his system. The drugs in his system in of itself would be a violation of his bond, whether he was acting out of sorts or not. So I'm going to revoke his bond, hold him without bond. And then you have a problem, ma'am? Would you like to go somewhere? There's room for you too. Okay, we leave the courtroom.
I'm not asking for the money to be forfeited. I'm just asking to be held.
They're not gonna forfeit anybody's money. Nobody's money's gonna be forfeited. Anybody that signed his bond to get him out, did so to get him out, and he hasn't done, it's not like anything else, okay? So let's get your calendars and let's set this case for trial. He's gonna be held without bond. And you have your calendar with you?
I do.
Let's look, what are the first dates that you have available? We'll check the defense counsel.
I would have the first week of June available, the 3rd, 4th, 5th, 6th, and 7th.
What about the 29th, May?
Yeah, I have that available.
Now, let's go the week before that, 21st and 22nd. Do you think that trial, that's a Monroe County trial, McClendon? And so you think that's going?
Miss Gordon Anderson doesn't think so.
We don't know for sure.
We don't
yet.
know for sure.
Yeah.
Well, let's schedule it for the 22nd, right? Okay?
Okay.
And can you make it on the 22nd?
I can, Your Honor. I have nothing on my calendar.
Good.
Is that all, Your Honor?
That's it. Thank you.
So that's further in front of court. May I be excused?
Absolutely.
Thank you.
Okay, let's go around docket here. Ray versus Ray, Cumberland County case. This is 23 CI 00060. Kristen Ray versus Christopher Ray, a motion to compel.
Yes, Your Honor. On behalf of the petitioner, I had served the defense respondent with some discovery requests back in December. I didn't receive any response. In March, I filed a motion to compel. That motion was supposed to be heard last week in Cumberland County. I allowed them an extension to move it to this week to get the responses, and I still don't have everything I need.
Tell us what you,
I'm still waiting on bank statements, and
let's be more particular than that. So
from January.
you can make a list
Yeah.
this way, okay?
Yeah, January of 2022 until present, just bank
January
statements.
of 2022 to present. Okay.
For bank statements, and then
Okay, whose accounts would they be on?
it would be the respondent, just any bank account that he has.
Christopher Ray?
Correct.
Okay.
And I'm also needing his retirement statements from January 2022 until present.
What's the significance of January 2022 as far as the retirement statements?
Just from that time period, I know that's when he had, in 2022 is when he started a job where he was getting retirement. We're just mainly,
Okay, what company is that with?
it's an electric company in Bowling Green.
Works for Warren RECC, Your Honor.
Okay, I just want to be specific so you know what to reply to. Is there anything else you need?
That's it. That's all I'm waiting on.
Okay, do you have any response to that?
Your Honor, my only response would be, I understand the retirement statements. We've got no issue with that. We just haven't been able to procure those yet. I don't understand the need for the bank statements. I'm not sure where it's relevant, what my client is spending his money on,
Was they
especially.
married during the time period?
Yes, Your Honor. They were married during that time. I mean, I think it's relevant to see if he's having any other income, if he's liquidated any assets, if there are more assets being purchased, during that time. I mean, I don't think they're very relevant.
Well, I would put an order on it that you and your client can see that no copies of it could be made and nothing could be disposed by you of
That's fine.
any nature on there. I don't see how you can look at these sort of things without having some access to bank records. Okay.
If that's the court's ruling, we can give that.
And Your Honor, just and I know because of the motion to compel, my client is going to be out some attorney fee, and, we've been waiting on these since December. I'd love to already settle this divorce, and they've been the holdup. If the court would consider a reasonable attorney fee for my client. Just to consider.
Well, I'm gonna award $350 attorney's fees, but I will suspend that if you comply with the order within, let's say, 10 days, okay? Can you do that in 10 days? I think that'd be fair.
Thank you.
That'd
Yeah,
get you behind.
that's fine.
I
Yeah.
think we can
She
get that in
she
10
doesn't
days.
do it within 10 days, she'll order $350.
I appreciate that.
Attorneys,
We
okay?
can do that. That's fine, Judge. Thank you.
Thank you.
Thank you, Your
very
Honor.
much,
Thank
yeah. Okay, are we ready for the civil docket? I guess so. Watkins versus, Babin, MD and others.
Your Honor, Bobby Whitmer on behalf of the VIP defendants here on Zoom, Dr. Babin, Dr. Watson.
Okay, you're gonna have to speak up. We've got a bad connection here.
Okay. Let me see if I can get my microphone a little better with my laptop here.
Last night, yeah, thank you so much. This is just a motion for leave to file a third-party complaint. Is that what this is?
That is correct, Your Honor.
Is there any objection to that?
Not from our side, Your Honor, of this plaintiff's.
Okay, who do you represent?
I represent the plaintiff, Your Honor.
Yeah, okay, and what, get behind the red dot there, and what is your complaint?
We just don't believe that venue statutes allow for the addition of defendants that could not have been brought in the suit initially. We cited the Copass case for that proposition. The apportionment statute, which is why they want to bring these defendants in, does not vest authority to bring defendants in from a different venue. Certainly.
Where are these defendants they wish to file for? Where are they located?
Barron County.
All the way over to Glasgow?
All the way over there, Your Honor. So that's the problem. Certainly, we would have brought this one lawsuit in one venue were we able to do that.
Well, this accomplishes that for you, doesn't it?
Except we're not allowed to do that.
Well, yeah, but they're doing it for you.
Well, I don't think the apportionment statute or the venue statutes allow that unless the Barron County defendants waive venue. That we can't force them to suit in Clinton County, even though we would like to.
Here's the, I'm gonna allow this, and if they object to the venue, I'll cross that bridge then. Okay? So.
There's the rule.
It's pretty quick ruling. Isn't it?
It is, Your Honor. We also have a pending summary judgment motion on behalf of the hospital. Just put that back on your radar. It's been pending for quite some.
It kind of is.
Okay.
It kind of is on the radar. Mr. Whitmer, is that you there?
Yes, Your Honor.
You'll prepare an order that just grants your motions, and then, of course, I'm on the record saying that once those people get served with that, if they come over and have a venue question here, then I'll address that. Okay?
Thank you, Your Honor. Thank you, Your Honor.
Okay, thank y'all very much.
Appreciate it.
Thank you.
Sorry we're running a little late.
That's okay.
Okay, Dyer Drug Management LLC versus CCPD LCC DBA Clinton Pharmacy.
Judge Dave, James Craig here for the plaintiff.
I'm here for the defendant, Your Honor.
If I may, Your Honor, there's a couple of pre-trial motions that are on for today.
Yeah.
I don't have a response in front of you yet because I'm asking for the court to provide some guidance on how to proceed. We were here in October on summary judgment arguments and a motion to set for trial. The motions that have been brought before you today are evidentiary in nature. I think they should be approached and addressed during the trial when this evidence is presented. Regardless, there was a July order from Your Honor, which set for all the pretrial deadlines in this case. And these April of 2024 motions 9 months later are well past that deadline. I think the case is ready to go to trial, and the complaints that Dr. Huff has or Mr. Huff has here this morning or this afternoon, we could address once we've got 12 in the box.
Go ahead and make your argument.
Well, Judge, it's common for, and I think I got a request from the court, file any other motions that we wanted to file to have pretrial evidentiary motions, hearings before a trial. That's a purpose of those type of most motions in limine. And we filed those well in time for the previous motion day.
Yeah.
I got a call.
It doesn't bother me that you file these motions. I did request any other kind of pretrial motions and things like that. Quite frankly, Mr. Craig, I'm having trouble getting my arms around what kind of case this is and who the parties are. And I've read things. You're a very good writer. Mr. Carroll, a very good writer. I was reading last night for quite a while on some of these things. And it appears to me that the motion that Mr. Carroll has about how you prove the damages is pretty interesting to me. And I never had, I guess till last night, I really hadn't gotten down to how you value these things, you know, how the number of prescriptions you have, whether you bring $11, $12, or $13 when you buy it. I read that. And then you're talking about it's alleged that 70 or 80 people were contacted by this former employee who did not have a non-compete that had worked for the other pharmacy. It made 70 or 80, and that she had testified under oath that she did that with a phone book and that she didn't have access to us. Now that would be.
She did testify she knew that patient medical information.
Well, she sure did. Yeah, because, well, she knew who the patients were because she'd worked there for 20-something years. You
And
know,
she-
I'm sure they did, but.
Knew the valuable ones too.
Well, sure that too, but she did that, even if she'd been asked to do that. If you could prove who the 80 people were and she made 80 of them, then would the damages be limited to the 80 people it looks like when the pharmacy, patients were distributed, they didn't all, you know, they didn't all go to Clinton County Pharmacy. Some of them went to Roberts Pharmacy, a good percentage of them, they went other places.
I wouldn't say a good percentage. I might describe it as a nominal.
28%. Was that what it was?
It was about 60-40 total, not just Roberts. The others was about 40. Our people was about 60.
Yeah.
Uh,
And how many of those were there that you got that were previously?
I can't say that off the top of my head, Judge.
Yeah. Well,
These are
Actually,
the factual issues that we need that jury for, Judge.
Judge, we also got 45% from the Roberts funds,
that's what I was thinking about, the 45%.
which we're not accused of.
Okay, let's just get back to me chasing a rabbit here to your motions you have today. Okay.
Okay, I had a motion to dismiss for failure to join an indispensable party.
And who is that?
We argued that, Judge, last October. That's been fully briefed.
It has.
There's an order in there that denied summary judgment and denied the motion to dismiss.
We don't have that order.
No, I've not seen it.
Both motions are denied.
It's good news. Thank you.
When you say both motions,
The motion for summary judgment, your motion for
Okay.
summary judgment, and your motion to dismiss.
I haven't received those. Then we have the motion to exclude their expert, motion on damages.
Okay, well, let's do one of them at a time.
Okay,
Okay, who's the indispensable party you're talking?
that would have been Shearer Ruggs.
Yeah.
Uh,
Something like somebody else.
no, that was Shearer Ruggs.
Okay.
And then we had the motion regarding their
And their
expert.
expert witness.
We had the motion to
I read the testimony of their expert witness. If I were you, I'd want their expert witness to testify.
well, there's two expert witnesses.
Okay, one of them.
One of them is an
That's
expert.
not true.
They're
I'm
not
sorry,
two
if
expert
if I may offer what the plaintiff is,
Which expert witness are you talking about?
I'm talking about Mr. Gruber, who was their quote unquote HIPAA expert.
Yeah.
It should be excluded for two reasons. One is, he made a lot of assumptions that weren't in evidence. He made opinions without reading depositions. Then he revised those
Well,
opinions.
let's address this HIPAA thing. Okay. I buy into what you're saying, that HIPAA is meant for the protection of the patient information. But aren't there cases, Mr. Carroll, where there are illegal activities that take place that could generate another action over here to an unprotected class? In other words, if you found somebody that was doing something illegal for the purpose of doing a torturous interference with something else, you could bring that up, couldn't you?
Actually, I don't think so, Judge.
That's what, yes.
Because
Well, see, my problem is if we go to trial, I'm trying to imagine what the instructions are gonna be like and what the findings are gonna be. And that's where I am in the stage of things to see. And if I can't come up with instructions that I think that can be reasonably supported by the proof, I might reconsider my motion to deny summary judgment. But you go ahead and talk about the expert witness. I read his statements last night, so go ahead.
Well, on the jury instructions, we do have some tender instructions.
Let's talk about the expert witness.
Well, and I would like, if I may, Your Honor, an opportunity, because I'm not sure where we were with respect to scheduling of the trial, to get you a written response 10 days after this hearing. But I can say today, Judge, Mr. Gruber, I know Dr. Gruber, excuse me, I know very well at this point after working with him extensively over this case. There's an allegation about what he reviewed in anticipation of forming his opinions. And then there's some arguments about whether or not those opinions would ultimately be helpful to the trier of fact. What he has reviewed are the statements of the witnesses that were put in at the time that Your Honor entered a temporary injunction against his client to keep him from using anything he took from the brochure. Now, he took Your Honor's factual findings that you made when you entered that temporary injunction against Huff. He took the complaint, which was verified, which constituted testimony from Dr.
Well, let me stop you there.
That, we're talking about everything.
Let me ask you a question about that. At the time I entered that temporary injunction, there was an allegation that there'd been a major download of a printout of information.
Yes.
And it seems like to me that that's kind of been refuted or been watered down. Now, in that there was any printing of it, there was 2 pages printed. Now, that doesn't mean that somebody didn't pull a screen up and take a picture of it, but nobody's ever, that's speculative and there's no list that's ever shown up. But go ahead.
Well, yeah, Your Honor, hard to disagree with that. 5 years later, you'll remember one of the reasons why you entered that injunction against Clinton County Pharmacy, against Huff, against Lawson, because they came here and testified that they weren't there, that none of this had happened, and we were able to show with the schedules that they actually were working on the day that this list was accessed, and this list was accessed for the first time in more than a year. They had no reason to access either Lawson or Huff. Their jobs are to fill individual prescriptions on a day-to-day basis. But on this day that Huff, when this pharmacy is about to get sold, accesses a list of every single patient that's ever been serviced by this pharmacy. And then a couple of months later, Carol Brown just magically remembers all the most lucrative patients and is able to call those. Your Honor, we don't have a copy.
How do you know she only called the most lucrative?
Oh, that's what she testified to, Judge.
I didn't see that. I didn't see.
She testified that she
You need to
knew.
show me, before you make a statement like that, you
Sure,
need to
Judge.
show me that, because I read them last night and I didn't see where she said any. She said she got people that she knew that she thought would be, she was asked by one of the partners to get people that might be interested in coming over. Is that correct, Mr. Carroll?
That's
What she
correct,
said?
Your Honor.
So that might be interested. So she was asked to make a judgment about who might be interested in coming over.
If I may, since I have been challenged on that, Your Honor,
Yeah.
can I read her testimony?
Absolutely.
The question, well, Carol, you know the customers. Do you mind getting our system up and running with these Kent Share customers? I'm talking about what Lawson and Huff have said to her.
Yeah.
Lawson.
Well, I don't know if he's exactly like you phrased it or not, but probably was, well, I guess. Well, you corrected me. I want to make sure that I'm not misleading anybody here, I'll say. Carol Brown, yes, he probably said that, that I knew the customers and who wanted to come, to ask them if they wanted to come. How would you know which ones wanted to come? Because I asked them. It is that solicitation of patients that the HIPAA marketing rule does
Oh,
not allow.
I have no doubt that she was solicited. And that Mr. Lawson told her to solicit people that would want to come. But you said that they did the most lucrative. And that's what I'm challenging on. I don't remember that. I'm not saying, but I just read it last night. But I would imagine if I was, go ahead, give me the lucrative part of it.
Okay, but you kind of knew. You worked for Kent for 20 years, and you said earlier, you knew which patients had the most prescriptions, right? Yeah, most of them. Yeah, because I dealt with them for years. And I knew the customers. They told me they wanted to come. So we didn't have anything, you know, like medical information and all that, we know. But you knew Kent Share's patient names. Yes. And some of their telephone numbers. Yes. She's admitting in her deposition that they're targeting the most lucrative.
I don't understand it that way, but you could argue that, but I don't understand.
And I think I can get 9 of the 12 jurors to agree with me.
Okay, go ahead.
I'm not sure where we are, Your Honor.
I'm not either.
Dr. Gruber is qualified. But all his opinion is on the law, which the court has to make a determination. He was also willing to make any kind of opinion.
Well, he also said in his testimony that HIPAA was for the protection of the patients and not the
He did.
protection of Walmart, I think. Isn't that right?
That's absolutely right.
You know, so.
But the Kentucky Supreme Court, as you just said a couple of minutes ago, provides that that is a standard for tortious interference.
What
And
is the standard?
Other unlawful conduct. If you do it maliciously, or if you violate some other standard of the law, the Kentucky Supreme Court tells us that is tortious interference. And that's why I don't have the order, neither does Tom yet, confident that that motion for summary judgment is probably.
Hey, you have anything else?
The key is tortious interference. There was no tortious interference. There has to be a tort committed by our client against their client.
Now, what are you down to on the tort that we're going to go to the jury on if you go there?
That's not a correct statement of the.
Well, let me ask you, maybe I didn't accept his statement. What is the tort that you're going to? Is it a tortious interference with business relationship? Is that the specific tort? Or is the tort more general and did something that they shouldn't have done?
There are 2 torts that are alleged in the complaint that I recall right now, and I've got it here if you give me a second.
You got a second.
Tortious interference with contracts and tortious interference with prospective contractual relationships. It's the very next the very next section of the restatement of law, and is addressed by that same Horn versus NCAA Kentucky Supreme Court case and a few of the others that we cited in response to that motion for summary judgment. The specific claims alleged in the complaint that we filed on April the 30th of 2020, here we are on the 4-year anniversary, are just those 2, tortious interference with contract and prospective contractual relations.
Well, let's start with the first one. One of the elements of that is there has to have been a breach of the contract, which in their response to their motion to dismiss have said there was no breach of the contract between Shearer and Dr. Collins.
That's the wrong contract, Judge.
What contract you talking about?
We're talking about the relationships between Dire Drug Management Company and its customers. It is the customer.
Well, at some point, your client has to be subject to a torturous act. There must be a torturous act that injured your client. And this torturous act I don't understand how you make that leap. You understand what I'm saying?
Absolutely, Judge. That's been kind of my argument all along.
There's no contract. There should have been some contracts.
There
should
were
have been a lot of,
contracts.
what contracts were there?
There were business relationships. So we're talking about a client, the client base, the lucrative ones, according to Carol Brown, are the ones who are about to get their scripts filled, their prescriptions at Dire Drug. And then every one of the relationships between.
Well, what is Carol Brown? You haven't sued Carol Brown. Okay. Carol Brown says that she denies being in contact with Mr. Huff, or doesn't remember in contact with Mr. Huff. She was in contact with Mr. Lawson and said that he asked her to call some people. Now, what obligation does Mr. Lawson have if a former employee comes to work for him that doesn't have an uncompete or anything? Okay. And he asked her, do you remember the patients that used to go over there to share a drug, would you call some of them to see if any of them want to come over here? Is that torturous conduct, you say?
Judge, Mr. Lawson here's a pharmacist. He's filling prescriptions. They have access to the most sensitive confidential information about residents in this county. And there's a specific federal law.
I'm talking about Mr. Lawson.
He's a pharmacist. He is an owner of the defendant.
Yeah, but he asked this lady to call people that used to be over there to see if they wanted to come to a new pharmacy. You think that solicitation is wrong? Is it illegal? Is it unethical? Is it barred by HIPAA? What is it barred by? I mean,
All of the above.
well, tell me how.
Well, Mr. Gruber's opinion walks us through that.
I read his opinion and he didn't say I didn't see whether he said anything. He said HIPAA was not, I can see where you can see that there was another wrongful act that was used if there was a contractual relationship between Dire Drug and some other entity, whether it's Shear or Clinton County or something. I'm just having, even though I denied your motion for summary judgment at the time, well, now that it comes time to do the instructions, I'm having a hard time seeing which tort we're going after and how you can say that something that Ms. Brown did at the request of Mr. Lawson, who was an employee of Dire Drug at one time also, correct?
He was a part-time employee at Shear Drug.
It's Shear Drug, it's Shear Drug.
He was.
So he was part-time there. And so there's no allegation. He didn't get into the HIPAA thing, look at any records that you can prove. I don't think, but this lady says how she chose the people, and she said she didn't have any list. She did it from memory. She went down to the phone book. You're saying that's a factual thing that the jury ought to decide.
Yes, Your Honor.
Well, even if they prove that, I'm just having a hard time connecting. What's the other?
That's why I might suggest, Your Honor, we need to do those instructions during the trial like we normally do after the proof comes.
I don't usually do trials, instructions during the trials. I always have the instructions done before the trials so we can address things like this and avoid tainting the jury. So if you will look at my pretrial orders, they all say that jury instructions should be submitted.
And they are, Your Honor.
Yeah.
They are.
Yeah. If you submitted jury instructions.
I have, Your
okay, I haven't seen the jury instructions, so I'll have to look at it.
It's been quite a
Quite a
while.
while.
But
Yeah.
it was amended, yeah.
That was before the summary judgment.
Summer of 23, at the same time we did summary judgment.
But time flies when you're having a good time.
We are.
Okay, well, okay, Nate, so your motions are about the expert witness and what was your?
And damages.
Yeah. How about the damages? How are you gonna prove damages?
Profitability, so we can look at the prescriptions that were being filled by the individual clients and how much the profit margin was on each individual. And
How do you know which ones were contacted? There were many others that went from, one pharmacy.
We have a list that went over there, and we're gonna.
How many went over there?
Judge, I don't have that in front.
Ballpark figure, I'm not, 300, 400?
I've looked at this significantly. We're looking at about 26,000, maybe 27,000 prescriptions.
I'm talking about individuals.
Over the individuals, we're talking over 100 at least.
100
That's
individuals.
We have good evidence through the testimony and the documents that have been exchanged, exhibits that are available to counsel, testimony that you're going to hear from Dr. Collins and other employees of the pharmacy. That's good evidence. Expert testimony on the damages that an individual suffers.
Okay, but you can't just use the people that went over. If they did, you'd go out and make the same argument about Roberts. Some people went from Roberts over to Clinton.
But there's no allegation in this case that Roberts violated their sacred pharmaceutical oaths.
Sacred pharmaceutical oath that Ms. Brown had, she made a sacred pharmaceutical oath.
It was the owner.
I want to know where the oath is that pharmacies can't solicit. Is there an ethical problem?
It's a
pharmacies with soliciting business from other pharmacies if they get an employee?
Yes.
They get an employee. What is that? What is it?
It's called the marketing rule, and it was, and I'm gonna pull up the response that we filed to the motion for summary judgment. It was quoted, at length in response to that, Your Honor. And I'm gonna need a second here, but specifically states that pharmacists are included in the regulations applicable to all doctors, that you're not allowed to use protected health information to solicit their business. You cannot do it. So I know that you're theoretically, my mother died a few years ago, diabetic, congestive heart failure, and Parkinson's. She was on a dopamine supplement for the
Are you
Parkinson's.
suggesting you have things from my medical records and think that's in my future?
No, Judge, I'm talking about my mother. But
If so, I'll just recuse and let some healthier person do this.
If Lawson knows what's going on with my mother, and she knows, and Lawson knows, or Carol Brown working for Lawson knows,
that she's a valuable
that
patient.
my mother is gonna deliver thousands and thousands of dollars a month, you cannot use that information to solicit my mother to come to your pharmacy. That is black and white law. It's black and white.
Now, what do you say?
The only thing that was used was the memory of Carol Brown of what she called her friends, who were the people that she, had served for 20 years at the
So you're
pharmacy.
saying that if there are 3 pharmacies here and I see somebody over in another pharmacy, that I do the equivalent of what the universities are doing with their basketball players. I go over there and pay them $75,000 or $100,000 to come work for me, and they know all the heavy users of various sort of pharmacies, so I can buy that information from them. They can come over.
Well, I think that's correct. They can come over, but
And provide that information that they know, and the specific reason that I hired them is because they worked over there and I knew they had that information.
there's not evidence of that, Judge. Carol Brown was fired. She came to work for us.
She was not fired. If there's an allegation she was fired, it is significantly disputed, but she was not fired.
Well, she wasn't hired away. I believe she testified that.
Her husband had some medical issues. She left for a little while.
There was kind of a midnight massacre over there when the place changed hands. Everybody left and didn't want to work there anymore.
Well, they all went.
And I may be confused with her and the other lady.
I didn't see anything about it.
Okay, I think he's right. She left. Christian Keystroke was fired.
It's kind of like all the UK basketball players left when they had a new coach when the coach left. And so when they had a new pharmacist, the other 2 pharmacists that were working there and some of the employees left because they didn't want to work there. So I understand. I don't see anything wrong with that. They didn't want to work there.
Well, that's not the allegation.
So Carol Brown has names.
What is
She
the
recalls.
allegation as to why they all left?
Well, it's not actionable. We're not suing anybody because an employee, but that's the point.
No, I was trying to be on your side on that. So,
It's the tortious interference. Yeah. And I do have that marketing.
It's
rule.
what they did after they left. Someone tortiously interfered with a former employee, So you're saying that if you have a former employee, you don't think it would be ever ethical for another pharmacy to hire them and say, call all the people that you served all these years to see if they want to come over with us?
I think sometimes the U.S. attorney would be interested in that allegation.
Based upon what?
45 CFR 164.502. HIPAA defines marketing as a communication about service that encourages recipients of the communication to use the service. That's marketing. Using protected health information to market a new pharmacy practice is prohibited unless this patient specifically authorizes it in writing in advance. Carol Brown's admission that she called patients that she had information about and asked them to come to the pharmacy is going to be the basis for a motion for a directed verdict in the trial.
Without their written consent.
Without their written consent. This is not going to be a liability issue once Carol Brown testifies. This is going to be a damages trial.
Okay, what do you got to say?
The operative word is protected health information. It's nowhere in any of the regulations that says a person's memory of a name is protected health information.
I kind of liked your argument when you said who was, an entity that's covered by HIPAA. And one of the criteria was someone that electronically transferred information. But that was identifying someone that electronically had information that they transferred. It wasn't that the information we're talking about was transferred. It was a criteria that established a kind of business. You understand what I'm saying? You said that, in other words, that's just, they were saying an entity that electronically transfers. It doesn't mean that the information that they use has to be electronically transferred. It can be downloaded. It just named the kind of companies that would be subject to it, providers. I don't buy that, you know. See what I'm saying?
I understand, Judge.
Okay.
But nowhere does it say a name, a patient's name is a covered entity.
Well, he's saying that they use more than the name, that they use the name and information about the various expensive prescriptions.
But as the
For
court,
example, you can have a diabetes candidate that can have prescriptions that cost thousands of dollars a month. And one of them is very valuable.
but Carol Brown did not testify that that was her criteria. She called her friends from Sheer Drugs that she thought would come.
You don't think she was goaded to the ones that had the most prescriptions?
No, I don't, there's no testimony
That testimony is weak on that point. I could see where you'd agree with that.
now, if the defendant were able to get to a jury, which I don't think they should, the maximum damages is those 60 or 70 customers.
And what do you say about that? That's a real stick.
Once we prove that they were violating their professional responsibilities and opening it up, I think that every prescription that left Dyer Grove and went to Clinton County Pharmacy in calendar year 2020, certainly before Your Honor issued a temporary injunction telling them to stop in December of 2020. And then every prescription that those folks would have had throughout the course of their relationship with Dyer Grove. That's tortious interference with contract, claim number one, what they were going to get filled. Tortious interference with prospective contractual relations, what they were going to get filled in the future. The interference through a violation.
So torturous interference is between the various patients in your client.
Yes.
Well, Judge,
Have you heard that before? Very much.
the tortious interference with contractual relations that they have alleged is the Shearer contract.
Well, I mean, had you heard the torturous interference between the patients and
His second cause of action appears to reference the patients. The first one references the Shearer drug contract, which they have admitted hasn't been violated.
We've been focused on these patients. The contract between Dyer Drug and Shearer provided for a transfer of the goodwill. Huff and Lawson completely interfered with that transfer. That transfer was not completed. These are thorny issues, Judge, but this is why we have to get in front of the jury.
The complaint and their admission is that we did not interfere with the contract between Shearer and them. Because there's no breach, they say there's no breach of the contract between Shearer and them. And they say that because that makes Shearer an indispensable party. So in their pleadings and in her testimony, Dr. Collins's testimony, she said that, admitted that there was not a breach of contract between Shearer, that she got everything that she bought.
so they're saying there was an interference and a tortious tortious interference in the contract, but the contract was valid.
Contract, so it couldn't be.
What do you say?
We didn't get all the goodwill, Judge. I mean, with Eric Collins and Dyer Drug Management Company sat down to buy from Sheer Drug, he closed it on a Halloween in 2019, didn't come over all the way because of their client's conduct that they've admitted to. You say the testimony isn't crystal clear, but it ain't a wall. It's pretty clear to me.
Okay, well, thank y'all for being here and putting up with me again today. I'll get you an order out pretty quick on this.
Can I just get 10 days to do a submission in response to the motions and,
You don't object to that?
I'm not going to object to it, but I would like to have 10 days after that, Judge.
You got it. And
can we get we'll be prepared, Your Honor. I do have a motion for a trial date that's been bumped a couple of times. I'm going to suggest July, if Your Honor has availability in the calendar. With things.
Well, let me look at these two things, and I can set your trial date. We're not clogged up. You know, it's not like you're going to for months and months and months.
We could do, could we get it at the request of the plaintiff, my client's vehement request? Can we go ahead and put it on the calendar?
No, I'm not going to put it on the calendar today. I want to see these two things, and then y'all won't have to come back here. We won't wait till another rule day. Once I get the response in an order on this, first we got to decide what we're going to trial on. Okay, and I'll look at these instructions. Have you objected to some of his instructions when we do it?
Your Honor did not have a pretrial order on that.
Well, I'm just asking. I'm not.
No, the only comment that I made about his instruction was at the last hearing that we had on the summary judgment motion was that one of the elements that he has in his instructions is that we interfered with that contract between Shearer and Dr. Collins. And I pointed out that she had in a motion that she had admitted that contract was fully performed. So we cannot have interfered because the element requires a breach of that contract. So if there's no breach, there's no interference.
Torturous interference by an outside party if the two principals didn't breach the contract, but someone else came in and did a torturous interference between their. That's what he's saying, that somebody else came in and interfered with the contract, not that either party breached.
There has to be a breach. That's one of the elements.
Judge, I haven't looked at these jury instructions in 12 months.
Okay, we need to look at that issue.
I would like to request at the same time that I make these submissions that the parties do simultaneous instruction objections.
I think that'd be good. It's kind of what simultaneous instruction objections and kind of focus on these elements. And then if we get down to instructions, we're a lot less likely to have to try this thing the second time if we get the instructions right the first time. And there might be things that you would concede on that are very questionable that you don't want to try, you know. Okay, well, thank y'all. 10 days and 10 days, or you want to expand it to 20 and 20 since we're talking about the instructions?
Let's do 20 and 20.
Let's simultaneously do 20 and simultaneously look at the instructions and focus on them right now. And they'll help me take a look at the entire case and the rulings on this thing too, okay?
Thank you, Judge.
Thank y'all very much.
Yes. 20 days for him to respond, 20 days for me, and then.
Well, let's do simultaneous work on these instructions,
Okay, and when would they do?
20 and 20.
I think everything's due in 20 days, Judge. And
Both
then
of
you'll
them,
have-
and then I'll give y'all each 10 days to reply if you want to.
Okay,
2020 on everything, but focus now mainly on the instructions. You know, and the expert witness thing bothers me a little bit, what he says. I don't know if when he did his deposition, if he really knew what the claim was, it seemed like. You know, I mean, he seemed a little confused about it. The smart guy, obviously very highly qualified guy.
I did not attack these qualifications, I don't believe.
I know, yeah. Very, very accomplished and been all over everywhere, works in some of the big dogs. Okay?
Thank you, Judge.
Thank you very much, yeah.
Thank you, it's good to see you.
Mitchell versus Mitchell. Hello. Okay, this is 20 CI 00135. What do we have today?
I think we're here on review. We have Ms. Perigin's report.
Okay,
We're in agreement with everything. It sounds like she was under the recommendation of a custodial evaluation. And we're in agreement with.
What, have you found somebody to do it yet?
Judge, I think I had put a recommendation in there. I had found somewhere called Shelton Forensics. They're out of Louisville and they seem to be substantially cheaper than anything I had saw in the record thus far. They said that they used doctoral level candidates to interview everyone. They interviewed the children with the father, with the mother.
How much was it?
I believe it was 2,600. Is that correct? Do you have the breakdown?
Okay. 2750 per person.
It's 2,750 per person. And that's per person, bro.
Well, does that mean everybody interview or what is it?
I believe that's the interview with dad and with mom.
How about the children?
And the children will also be evaluated in the presence of dad and mom.
He's asking if the $2,700 is all inclusive. In other words, every interview that needs to be done with this gentleman and the children and everybody, if that's.
It was my understanding that it was. Did you look at that?
Splendid, yes.
But what does that say? Custodial evaluation. So that should be everything.
That's what I'm saying, yeah. It says
Well,
step parents or other live-in family members, caregiver roles.
understanding prevents misunderstanding.
But now, and they do have some other things like what I'm found in here, but I
Yes.
think we just start with that one probably.
Right, right. My only concern was the children just didn't seem to have any real knowledge of the dad. They seemed to be very well-rounded children. They were very respectful, very talkative. And I just did not want any negative behaviors to result from throwing them in with someone that they had never met at this point.
Well, therein lies the problem, because, unless you terminate his parental rights, and he's got a right to have him thrown in at some juncture. We're just trying to figure out how to do that.
And that's something we were trying to, because I wasn't her attorney then, and we were trying to get copies of that file. She said that we previously filed that and those were dismissed. Was there, I was trying to figure out if there actually was a hearing on that. Yes, on the termination, was there actually ever a hearing on that, or was that something that?
It was
I don't think.
stated in open court at some point in time that it wasn't going to be pursued or wasn't going to go anywhere out of order. Because it's just a delaying tactic, quite frankly. That's our position. As everything else.
Well, and I do think, I mean, ultimately, I think that's something that's just because of,
What?
I think ultimately that's something she would like to pursue just because
Well,
of
I'm
the.
sure, that's the reason it's been, I do think things have been delayed and delayed and delayed. And it's the only case I've got like this where all this expensive, this stuff comes in. And I will admit that some of his prior actions caused this reticence to go ahead, for take place, but, obviously the children don't know much about him because he hadn't been allowed to be around the children. That's the reason they don't know anything about him. But can your client go with the 2,700 for these people?
Yes.
Your client, well, let's set them up just as soon as possible. And you talk to these people and tell them they need to get us an all-in deal. We don't want to, I'm sure you never had played any poker and know what string betting is, but that's when somebody bets $100 and see how your action in this, and that's $200. So we don't want them string betting us. We want to give them a price so they can both financially prepare for it and get this done. And let's do it, and I'll just do an order on that effect with me and then inform the court when it's scheduled for. Okay?
Your Honor, I want commend Ms. Harrison for her timeliness and diligence in getting something out on this. That's what we.
Does that mean she can put a larger bill in?
Well, her.
I think so.
Her bill was very fair.
Yeah, okay.
And now, point of clarification, or as Leo Sewell would say, understanding prevents misunderstanding. Ms. Persian is remaining in the case, even though she's going to be out of commission for a while. Is that correct?
Well, she'll be out of commission, but she'll be available with the phone, I guess.
You can Zoom me or phone
She's
or.
not relieved or anything. That's fine.
She will be relieved here in about 2 months.
Less than that, I think.
Less than that, yeah.
Yeah, okay, well, let's just don't get relieved today, okay?
No.
Okay, well, thank y'all very much.
Thank you.
Okay.
Capital One versus Lynn Starnes.
Good afternoon, Judge. William Rich on behalf of the plaintiff. It's a motion for summary judgment. The defendant filed a pro se answer to the complaint, which is basically an admission, but pleads that she intends to file bankruptcy. She filed that back in November. I can assure the court I checked Pacer about 15 minutes ago. Frankly, I don't know whether Clinton County would be considered Western District of Kentucky or Eastern District, so I just checked both. But there's no Lynn Starnes bankruptcy filed in either Eastern District or Western District of Kentucky.
Clinton County's in the Western District, isn't it, for bankruptcy, is what I thought. Does Wayne go to East? Yeah, that's what I thought from. Clinton is in the West.
And that makes sense. I think she said she retained a bankruptcy attorney in Bowling Green, so that makes sense, but there's been no bankruptcy filed.
Okay, I signed your order.
Very good, Judge. Thank you. Have a good day.
Look forward to seeing you here someday.
I would be happy.
I'm very familiar with it. I'm very familiar with the inside of your car. It's not nice vehicle.
Yes, sir.
Okay.
Thank you. Have a
People's
good day.
Bank and Trust, Pickett versus Post and Dalton.
Good afternoon, Your Honor. Christy Adams appearing for tax merchants. It's our motion to allow payment of several of tax merchants' claims. And I've heard no objection. Mr. Pickett or Mr. Brown has sent me an email indicating that the Pickett Bank had no objection.
I've heard the same thing, Your Honor. As Master Commissioner, I don't think I have a position.
Hey, you had tax bill, your tax bill 218, 219, 220, and 221. The amounts that you've asked, 3,400, 2,600, 27, and 26 are the unpaid taxes plus cost.
Well, what I did was I set out the initial bill, which is what the interest runs on. And then I filed a copy of the
Okay, I'm
payoff.
just, okay, this order amending judgment and order of sale to provide for payment of tax merchants. What are these amounts, those four amounts? What are they here?
These amounts, the 3,498.31 is for tax bill, the tax year 2018.
Now, what was the tax bill then?
The tax bill is, let's see, Exhibit A. The purchase price, Your Honor, is $34.98.31. And that's included as Exhibit A.
Okay,
And
the tax bill
Yes, Judge.
was 34.98.31, and you're getting 69.72.
Well, with interest and the itemized,
Yeah, I need a simple answer
Fees.
here. I can't follow, I'm not following. I just want to, the 34.98.31 was the tax bill. Is that correct?
Yes, sir.
Okay. The 69.72 was interest plus allowable fees.
The total due would be $6,972.17 is set forth on our payoff, which is Exhibit A in
Okay, so
parentheses.
the answer to that is,
So
the answer is the tax bill was $3,498.31. And your total judgment that you're asking for, which includes attorney's fees, advance calls, interest and everything, is $6,972.17.
Yes, Your Honor.
Okay, and that's true on each one of those. You agree with that?
Yes.
What do you got in this, Mr.
Actually,
Claus?
I'm actually tax bill maybe slightly lower than that. I think that was their purchase price. I think there were some additional charges.
Did you purchase it from someone else other than the?
No, this was
County.
purchased, the actual tax bill was Exhibit A. And it shows the purchase price at $34,98.31.
Was that paid to the entities here in Clinton County?
And we purchased that from Clinton County.
Yeah, so it was.
That was the purchase price. The bill itself was $2,054.
So
Okay.
some interest had run up on it before they purchased it. Is that what you're saying?
Well,
There's
no.
charges in between, you know, the taxpayer will get billed. And when it gets sold, they're put on, and they pay those.
Yeah, but this is their call. So that's what I'm asking. They purchased the tax bill for $3,490. They didn't purchase it from someone else that purchased it and marked it up. That's what I'm asking.
So the interest runs on the $34,98.31, Your Honor, the purchase price. And then the statutory fees are all
So
set
you didn't get
forth.
over the $2,500. What is this $2,500 where you have to explain extraordinary services or something like that?
I'm sorry, Judge.
How much is it that you have to, if it's over 2,400 or something, you have to say that you did extra work or something? What is that amount?
Oh, well, the attorney fees,
Yeah.
yes. If the attorney fees are over 2,000, you have to ask special.
I understand. So
Permission,
what I'm
so-
asking in this case, the attorney's fees are included in $6,972 and they're less than
Yes,
2,000.
Judge, and I only charged one attorney fee of the $350 on the first bill.
Yeah, I'm just asking to
Other-
make sure what I'm signing, okay?
I understand,
Okay,
Judge.
go forth and rejoice. I have signed your order.
Thank you, Judge.
Thank you. Dishman versus Clinton County Fiscal Court.
Afternoon, Your Honor.
Yes.
Aaron Smith for Clinton County Fiscal Court and Judge Executive Craig.
Okay.
This is,
Say your piece.
yes, sir. This is our motion to dismiss, Judge. I assume you've read the complaint in our motion, so I won't waste a lot of your time, but this is a case over the county record list arising from last October. We've moved to dismiss on the basis that the county's entitled to sovereign immunity, which is fairly straightforward. I know you're familiar with that, Judge.
I'm not a big fan of it, but I'm familiar.
Official capacity.
I've wrestled with it all my life to see what they're immune from and what they aren't and the differences between. So what do you have to say about it?
Your Honor, and I'm not sure if the court has reviewed, I was only able to get my response e-filed late last night, and I'm not
I
sure if the
haven't
clerk's
seen
office.
yours. I saw this stuff.
Your Honor, essentially, there are two issues here. First is the defendant, Clinton County Fiscal Court, and whether they have immunity. And then there's the issue with Judge Craig and whether he has immunity. On the fiscal court issue, we argue that immunity should not cover here. This is not your typical tort case where there's a slip and fall or an injury or something like that. This is, Judge, a case where we have alleged interference and fraud on the part of the fiscal court. I know that's probably not a great argument, and I understand that the cases are against me, but that's the argument we've made as far as the fiscal court goes. The stronger case in response we have, Judge, I'm just being frank with the court, The better
I can't
argument, Your
stand me in candor after today. I mean, don't give me in candor. It's because you're on.
Your Honor, with respect to Judge Craig, he has been sued individually, not in his official capacity. He has been sued as an individual for tortious interference with a business relationship, fraud, promissory estoppel. Your Honor, Judge Craig does not have immunity in this case. He was not performing a function as the judge executive.
What do you allege you did?
Your Honor, our allegations are.
Really tell.
Our allegations are that Mr. Dishman is a Wayne County resident, owns a record service there. He's also a magistrate in Wayne County. He spoke with Judge Craig about being a member of the rotational record list here in Clinton County and was told that he was on the list or would be on the list. Mr. Dishman owns equipment. He bought a new record or another record to use for Clinton County. He hired a Clinton County resident to work full-time for him. He leased property in Clinton County to hold these towed vehicles. He has enough liability insurance to cover anything that he will be hauling. After he was induced into this, he gets a call from Judge Craig later on saying.
Let me ask you. He wasn't induced into it. He was one that made the inquiry.
He wanted to do it and then was told that he would be on the list. And then afterwards, he gets a call one day from Judge Craig saying that he will no longer be on the list. There's no real explanation given. There's no action by the fiscal court that we are aware of. We're not aware of any action by the fiscal court really, and ever including somebody from the list or taking them off of it. We think that this was Judge Craig unilaterally doing this.
Okay, the list, who holds the magical list and who makes the phone calls?
It's my understanding that this is something that's done through Clinton County 911, which is under the auspices of the Clinton County Fiscal Court. There is an individual who is
That's where the list is.
That's my understanding is where the list is.
The 911 coordinator is the one that makes the calls, or does the sheriff department call over and say who's next on the list, or who does that?
It's my understanding that when law enforcement is working a situation where a vehicle needs to be towed, they will call in and say, if the owner does not have a specific request as to who tows, they will call in and say, we need the next on the list. That's my understanding of how this works, Your Honor. It's also my understanding, and I think that if this case is allowed to proceed and go into discovery, I think that we could show that Judge Craig went to 911, more than likely with another individual who owns a record service in Clinton County. And then it was after they went to the 911 center together that Mr. Dishman got this call stating that he would no longer be on this list of towed vehicles.
Would your client like to be on the list?
Very much so. Well, Judge, I say that he wanted to be. Now that all this has happened, Judge, I'm not sure if he can, I don't know. I'm going to say I don't know. I think he wanted to be. And Your Honor, I would say that.
What are your damages?
The damages are his cost and what he purchased and leased in anticipation of setting up operations in Clinton County.
How much is that?
It would be.
Give me a low ball.
I would say approximately $40,000.
What would that be for?
Well, he purchased this truck. Judge, if I could look very quickly, I should have this in my file. I apologize for.
The truck says use only in Clinton County.
It's well, no, but he had all this equipment in Wayne County that he has used. This truck was bought specifically for Clinton County. It was around $30,000 for the truck.
It was a shinier truck.
It was, and it wasn't even a new truck, Judge. This was a 98 Kenworth that he bought that was going to do the job, but it was still $30,000. And then he's got about $3,500 to $4,000 extra dollars in lease for the property and upgrades that he made to the property to be able to hold the vehicles, make sure the fence was in good order to store the vehicles and all of that. I would also note, Mr. Dishman has been doing some tows in Clinton County, but he has only done ones that have been specifically requested through the KSP post, which is separate from the.
They got their own list?
Apparently they've got their own list in the Columbia post.
Everybody's got a list.
Everybody's got a list. That's right.
I'm on a few people's list.
Couple things in response, Judge. Judge Executive Craig was, I think it's undisputed, he was acting in his capacity as Judge Executive. And you know, statutorily, the broad powers allowed to the Judge Executive, which would include management of record lists, contractual matters, all those things. The other issue that confronted is plaintiff is not even alleged they have some property right in being on the record list because it doesn't exist. I think it's up to the county to determine who, what, and when is on the record list, and the Judge Executive, amongst others, has authority to, in discretion to make those decisions. So, Judge, to the extent that the Judge Executive Craig is sued in his individual capacity, he's entitled to qualified immunity because he was acting as Judge Executive and making a discretionary decision. There's not some law that says, Judge Executive, you shall put Mr. Dishman on the list. And absent that, it's not ministerial, it's discretionary and immunity applies. Last thing I'd point out for the court, as Judge Executive of the county and an agent of the county, in fact, the chief agent, Judge Craig can't interfere with the business relations of the county. It's got to be a third party. You just had a big, long hearing about these similar issues.
I'm sure you enjoyed it.
I did. I found it somewhat enlightening.
Yeah, later on, you can whisper in my ear and tell me what's.
But it goes back to, you got to have a third party to come in and interfere with A and B's relationship. We don't have that here. The allegation is that an agent of the county, the boss of the county, so to speak, interfered with the county's own relations, and the law just doesn't support that kind of claim. So we've pointed that out as well, Judge.
Does your client still need the truck? Maybe the county could purchase the truck. You know, there's bound to be some reasonable exit for the client.
Judge, I don't know the answer to that.
Well, here's the thing about it. I think that there needs to be some sort of mediation for this thing. I think this sovereign immunity thing has tentacles that spread everywhere. You know, and it makes your client's case a little tenuous all the time, even if we decide something one way. It's not the sort of thing that, because, you know, the courts seem to protect sovereign immunity pretty well, whether they like it or not. You know. I don't know. And, I don't really think that KCO or anyone else, I'm sure that KCO represents the county. I don't think KCO is wanting to foist a bunch of money up to set a precedent that they'll settle a case like this. They'll probably try it, you know. And I know you're not afraid to try a case. You know.
Not so far, Judge.
It would, well, so you get a bad one and they ring you, but there's not enough money involved in this one to hit you that much. You know, you're not going to be having like a super medical expert that drains you and you egg out or anything, you know. I would suggest that I know there are probably some hard feelings on this thing. I would suggest that you check with the county judge executive and see if this gentleman can get back on the list of rotation. It appears there is a reputable person according to Kentucky State Police. I don't know whether I know him or not. I might.
He's a magistrate in Wayne County,
No, I know,
Judge, has
but
been
it's been a
for
lot.
several years.
It's a long time since I represented Wayne County, you know? So probably was then.
His father was magistrate before him, and you might have known him
I
also.
probably knew his grandfather.
Probably so.
Papa Dishman that came over with balance or somebody that. Yeah. But why don't you see if he's willing to put him on the list, okay? And then let your client see if getting on the list outweighs continuing this. And I don't know how frequently they rotate through the list or anything like that.
I don't think that there are many record companies that would be on the list. So I think that's part of the deal is he was kind of getting on this.
Just, why don't you contact county judge and see if he's willing to be on, let him on the list, you know?
I'll do that, Your Honor. I don't know the answer.
I don't either, you know. With forgiving heart, let the guy that sues you back on the list. But, and then you need to see if your client would consider something like that. As far as these motions today, I'm not going to dismiss a case like this. I might summary it out later, but I don't really dismiss it as a little rough. You know, it's just a little bit different standard. So I'm going to deny your motion to dismiss, but I will accept when you take a little proof or something. Motion for summary judgment based upon sovereign immunity. You need to see what your client wants, a certain thing, certain result. And, you know, everybody try to get along on this thing. So.
Okay. You need financial.
Oh, let me look at that. I want to get an order first, Judge. I don't know when you'll be able to get that out.
Well, you get, once you submit me one, circulate to him, I get one out right away.
The other thing, if I could request, Judge, I understand my granting with regard to the judge executive, because that's an individual capacity claim. I think it's pretty clear the county itself, fiscal court is entitled to sovereign immunity. And so what I would request, because here's the pickle I get into. I think there's a matter of law they're entitled to. That would get the county out. Maybe the judge executive stays in until we can do some discovery. I understand that. I, in some cases, am obligated to take up an interlocutory appeal of a denial of immunity.
Well, I mean,
That's not a.
That's the way you make your living.
It is, but I'm also trying.
to get overturned.
Yeah, I'm also trying to be as efficient as I can in resolving disputes. So, that's just my ask. If the court could rule, on sovereign immunity with regard to the county and grant that, I certainly understand leaving the case here.
How do you feel about sovereign immunity?
Your Honor, I think the court was correct the first time in denying the motion in its entirety.
I know, but I'm asking you.
Judge, I'll put it like this. On the cases I have looked at, cases say that counties are cloaked with sovereign immunity. My essential argument in this was, as public policy, it's bad public policy for the court to grant a fiscal court immunity when there are allegations that government is participating in fraud.
Change that policy. I think that's a good argument. I'll grant the county. As far as the county is concerned, motion to dismiss, and you need to put it in there based upon the law, what it is, giving them up to, give them a break. And you can look at it to make sure you're preserved on it, okay?
Yes, sir.
I'll tender an order.
Then we'll leave the judge thing to see if they can put the guy back on the list. You know, I don't know the guy. There might be some reason they didn't want him on the list. I don't know. Okay?
Thank you, Judge.
Thank you, Your Honor.
Second, finish the document.
Motion for schedule. No, I got it confidential. Yeah, I got it.
Okay.
No, you see it.
Okay, the next thing is the confidential document. Okay. Is everyone out of the courtroom that's not involved in this confidential? This is 24 AD. Alan Gabriel Pedrosa, excuse me. What do you have, Ms. White?
Your Honor, this is our motion or petition for involuntary termination of parental rights of the biological father of this child. The mother is Rosie O. She goes by Rosie Pedrosa, and she is here present today.
And what's the father's name?
His name is Fernando Zavala Salinas.
And where is he located?
He has been gone for 2 years. He has not provided any type of information where his location is.
So y'all don't know where he is?
No, there was a warning order attorney appointed, which
Who's the
is
warning order?
Mr. Whitmer.
Were you able to obtain service on him?
No, we thought we located in Texas, and we got a call from an interpreter that we had the wrong person.
I'm guarding that on your
And what do you have to say about it?
Well,
Come about over here where I can hear you.
Your Honor, I filed a response, but just in summary on my response, I met with the mother and the little boy. The little boy is a great little boy, cute as a button. And he's been without a father for 2 years. We don't know where the father is.
How old is he?
He's 6.
6.
And, you know, I think he needs some stability and some finality. And if dad's gone and he's not made any effort, there's been no calls, no texts, no emails, no visits, no anything for 2 years. Actually, it's been over 2 years. March of 2022 was the last time he had any contact. So in my mind, the criteria under KRS 625 have been met. And my request to the court would be that the court proceed with the termination of the parental rights.
You have anything to add to that?
No, Your Honor.
You have an order?
I do have orders.
Electronically filed?
And my client had also asked that the child's name be changed, his last name be changed to Pedrosa. Your Honor, I provided two orders, one with the father's name and one without. The first one is.
Did you electronically file them or?
I didn't. I
Okay.
got them done this morning. Thought I'd bring them.
Okay, well, we'll take a look at these. I see no reason. Staff attorney will review them and I'll probably sign them today. Do you have a?
Sir, I had an order just to approve my fees.
Okay, there was already one in there. I
Was
guess.
there an order in there? I didn't think I tendered that.
I think Mr. Whitmer had filed them.
Yeah, that was his for the one more attorney. Okay.
If y'all will wait on that.
Okay,
If you're gonna need a copy of my report, I filed that electronically.
that's okay. File electronically file. I'll go ahead and sign an approval of your fee.
Thank you, Your Honor.
And we'll probably sign this other one before we leave here today.
All right, thank you, Your Honor.
Thank you all very much.
You took one of these.
Go off the record.
Ryder, what do you think about the basketball?
Yeah, what do you think?
Calm that deal.
Gonna be an interesting season.
Especially when Arkansas comes to play.